Good evening, chat. Not Merry Christmas yet, but Merry Christmas Eve. I think that's what people say here. Real quick, Garrett Pate says he's late, he's fat, he's pregnant. Womp, 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 womp. Sorry about that one. Don't worry, there'll be a lot of coping to go around. And then Shugi Show, for one night says, late buying Xmas PJs for him and Clyde. Well, no, we were on time. Started at 10 o'clock. That's all that matters, but thank you for being here, Chugi. But yes, guys, I'm going to bring on not really our guest, because we're dual streaming out here, chat. But my joining us tonight, or maybe I'm joining him technically, I don't know how you want to look at it. Either way, is esteemed, attorney and also good content creator now. Is now officially in the monetized game. He's learning how to get the grift going, getting it done out there. Guys, you know him. Friend of the show, friend of the channel, hopefully friend of yours. Ryan Mullally. Ryan, how you doing?
Hey, buddy. Good to be back here. And thanks for the kind introduction. I may be a fellow attorney, but I'm only an amateur grifter. So I'm trying to learn how to oil up chat with the best of them.
Yeah. Well, you're doing pretty good so far. Doing really good over there. Guys, over at Twitter and YouTube at Ryan Mullally. And real quick, EDW Red for $2 says, I am super horny right now. So hey, I don't know if this makes you horny, but okay. But we all got our thing.
It's the suspenders.
Yeah. Stephen Cooper's been a member for 24 months. He says, this chat is disgusting. Let's green it up. And Stephen Cooper for 20 subs. Let's go tonight, chat. Yes, we are here to make America green again, chat. That's right. Pray the gray away. Just look at those greens. You tell them keep moving, keep grays moving. This is a green neighborhood, and just for that though, Clyde has to jump in here. Actually, hold on. Speaking of,
this is the stuff I need to learn.
Yeah.
I need a cute animal to reward the Oilers.
You need to catch the animal when he does something cute like this. Come here, Bubba. Hey. So I'm trying to grab him, guys, but yes. Oh, hold on here. I'm going to grab him real quick. Okay, come here. Come on, buddy. Hey. Come here. No. Come on.
EDW Raptor, thank you so much. I appreciate that, buddy. I appreciate the Christmas love and appreciate the best wishes.
Yeah.
And monetization was, oh my goodness, look at that pupper. Oh my goodness.
Yes. There you go. Yes.
Oh,
he's a good boy.
What a good boy. I'm sorry.
He supports.
I appreciate the 10, but the puppy's stealing your shine right now for sure.
It's when you talk about a dog, it's an internet rule. When they know there's a dog, they have to see the dog. He's being such a good boy. You're going to give him a woo again? No. All right. Jefferson Post says, Sean oils us up with butter here. All right, buddy. All right, I'm going to sit you down on the ground.
That's a good pupper right there.
Yeah, but you just borrow a dog, go rent one from the shelter.
Borrow it.
20 subs or Ryan takes it back to the shelter.
Yeah. You want the dog to have a good life? Come on.
Yes. No, it works. It works for him. All right. Guys. And Ryan, I don't know if you've had a chance to read this yet, but there was a ruling today in regards to, I don't think this applies to the DC deployment, but I think it applies to every state level deployment of the National Guard.
Yeah.
I don't know. I haven't read it yet, so I don't know if it discusses.
This is a pretty big ruling. Now, I don't know if you want how much of the background you want me to give, or if you wanted to give.
Yeah, no, you can start it.
It doesn't affect the DC National Guard because that's DC is inherently federal.
Yes.
So that's a very different thing than deploying the National Guard in the state. But the big news today is that the Supreme Court issued an order. It's not a full reasoned opinion, but it did have text. It wasn't just like a thou shalt order.
Yes.
Which ruled that the current legal theory under which the National Guard was deployed essentially in every place it was deployed. California, Portland, Illinois, everywhere. Other than DC, is now dead letter. So the Supreme Court has spoken. This is no longer a viable legal theory in really any way, shape, or form. So now the ball's going to be in the Trump administration's court to decide: are they going to advance a new legal theory? Are they going to invoke the Insurrection Act? But what they were doing previously is no longer legally viable.
Yeah, and I know somebody messaged me saying, well, it's just denying the stay. It's like, okay, yes, it's just denying the stay, but the Supreme Court is telling you, we're not buying this, so even if it came to us, we wouldn't buy this right now. And yeah, they're going to have to come up with something, but it's really kind of hard to pivot at this point. Like, they have to figure out what they're going to do, but it's not that simple. It's not that simple. So this is actually if you are supporting this, this is a major issue.
Yeah, this is a big loss in terms of, and I take the point you're making. Some people say like, oh, well, technically this was preliminary relief. It wasn't a merits level decision. And I'm sure we'll get into this. There is some wiggle room. The court in some places, the court left a little wiggle room to change their mind later. But at the heart of this, for those of you who've been following this closely and are law nerds, basically at every level, there's been argued about the legality of the deployment of the National Guard. And there were various theories advanced about why it might be illegal or legal. And to get into the weeds of that, you have to look at 10 USC 12406, which is the statute that governs the legality of the deployment of the National Guard. And there's a bunch of arguments that we've all been spending a lot of time thinking about. And then there was a dead argument. It was played out at the district court, but everybody thought this argument was dead and gone. And the Supreme Court resurrected it and actually asked for a supplemental briefing. So, Sean has it up now.
So these are the three things for, and guys, I mentioned this before, and I don't know if you've touched on it with your viewers. There are two parts to the military. There's, Title 10, which is the National Guard being called up. Then there's Title 32, which is when the Guard's running around under state level authority. So those are two different things there. So if you know people who are in the National Guard, you'll hear them say like Title 10, Title 32 things. But this is the National Guard call-ups. And obviously the invasion or danger of a foreign nation, no, number one doesn't work. I think we all agree number one doesn't work. What Trump has been arguing is number three, the president's unable with the regular forces to execute the laws of the United States. And this is the one they've been focused on. The one they tried to earlier bring up and go on was there's a rebellion or danger of rebellion against the authority of the United States government. And that was the one that was kind of like, kind of iffy. And yeah, we're going to get to all that. But these are the three options. Is there an invasion? Well, we agree that one doesn't count. So we're left with these two. And that's kind of where we are.
And the third one was especially important for a few reasons. One, just as a matter of fact, the lower courts, that was the one that they granted authority under. Like, both arguments under 2 and 3 were advanced, but like at least in the Ninth Circuit, that 3 was the one that they eventually said justified the deployment. So in many senses, 3 was just the one that was important for that reason. But also 3, he didn't exactly use the magic words, but in his authorizing memo to the Department of War, Trump used language that was very reminiscent of 3. Like, I think if I have it here, he says, the members of the Illinois, this is about Illinois, the members of the Illinois National Guard called to federal service shall protect ICE, FPS, and other United States government personnel who are executing federal law in the state of Illinois and federal property in the state of Illinois, and they shall do so at any locations which violent demonstrations prevent the execution of federal law. So he didn't cite the statute, but he kept saying they're here to make sure that there can be execution of the federal law. So Trump also, at least in his memo regarding Illinois, leaned into subsection 3, which is why that particular justification was bearing so much weight.
Yes. In chat, yes, he calls it Illinois. We here call it Illinois, but yes, the same
Illinois.
place. Illinois, yes.
I'm sorry, I'm not a native. I'll adjust.
You got to get the French in there, but yes. No, and guys, that is the thing that was going on there, and we talked about this before. Because it's federal property, Trump could call in the 82nd Airborne Division. They could come parachuting out of an airplane and land in the Portland Ice Facility and stand around protected all they want because it's federal property. He could call in Delta Force, and they could come in on their helicopters, the Little Bird helicopters riding on the benches and come and land and protect the federal facility. That's not really an issue because he could direct them to do whatever he wants. Now, he is not doing that because, there's some optics involved in that. And I think this was also that looks bad because he's putting the army out there. But I think this was ultimately also, like many of the things Trump is doing, we're finding out the limits of Article 2, and he was having a contest with the states. And I think that was something he was trying to do now to establish precedent later for whatever he may do. I think there was a little bit of that there. That's why he called up the National Guard. And there's a reason why he chose the California National Guard in that situation there. In these two cases, I think there's some strategic lawfare being engaged in here.
There's definitely high politics at issue. Yes. And also, the Supreme Court noted that there's never been a Supreme Court case interpreting this statute before. Mm-hmm. So there's just a lot of uncertainty about what the president is or is not allowed to do. We see the language.
But what does it mean?
And you have to interpret it. You have to know what it means. And in the lower courts, this argument about Section 3, does regular forces mean regular federal forces, i.e. ICE, FBI, law enforcement forces, or does it refer to military forces? This argument was raised and eventually abandoned. And there were other arguments that were going back and forth. But normally, and this is a little bit like inside baseball about lawyers, but normally when you're litigating, your problem is that you have so many cases to pick from. And you have to do all this research and read a million cases and distill some kind of theory. But there's good cases for the other side too. Here, there's nothing. There's just nothing. Like there's no ink has really been spilled on what these words mean. So it's a little bit like the Wild West out there.
Yeah, and that's actually, you're right. It's tougher that way because you're making an argument and you're like, well, what supports that? No, because I'm right. And that's the only argument you have sometimes. Very rarely this happens. And it's not fun because you have no idea what you can do to support it. And in this situation, there's nothing really even remotely close to analogous. That's another problem for both sides. There's nothing they can point to say, hey, this is not exactly what we're talking about, but it's close. Look at it. There's nothing remotely close to it. And the things you can worry about are like the Mott case from 1818. And you're like, that's not super helpful. There's very little out there precedent wise to draw from.
Well, Mott was very helpful. And, again, this is kind of like we're all kind of catching up right now because the Supreme Court really did something very different than we can get into this. There were signs, but in the lower courts, what they were all arguing about was what level of deference to give to a presidential determination. And that's where Mott was really useful, right? Mott's all about you have to give deference to the president.
Yes.
And all the fights were about, well, the president says we can't execute the laws in Portland or LA because of the riots. And then the other side says, well, come on. Let's look at the facts. Is it really that bad here? Are you saying you really can't execute the laws? You're still deporting people. Obviously, you're executing the laws. And then government officials give affidavits that talk about what the protesters are doing and how they're blocking cars and this and that sort of thing. And there's a fight about how much deference do we give the president? The president said that number 3 applies. Do we defer to him or do we second guess him as the courts? And that's what everybody thought the case was about. That's what all the litigation was about in the 9th Circuit, the 7th Circuit. That's what everything was about. But then they get to the Supreme Court, and the Supreme Court, after reading their briefs, writes them a second order and says, "Hey, you guys didn't talk about what the words regular forces means. Write us some letters about what regular forces mean."
Yeah.
And that was kind of the warning where everyone in the legal community went, "Oh, this might there might be a curveball here." And now, lo and behold, the curveball came.
And that's the neat thing when you're the Supreme Court. You get to say, no. We actually think there's a bigger issue here you guys haven't touched on. And they get that ability. So when we get to this, guys, just understand we're going to see multiple things pop up in here. So here we go. Also, guys, I know a bunch of people messaged me about some of the Epstein stuff that came out about the Trump claiming he raped a girl. Note that tip, if you read the second page of that guy also claims that Hillary Clinton ordered Terry Nichols to bomb the Oklahoma City building. So I'm pretty sure that guy is probably not a reliable tipster.
Well, we did a stream on this a while back, and boy, did we call that, where it's like, look, the thing about these files is there's going to be all sorts of nonsense in there, and every time something comes out, we're going to have to go through this exercise of, hey, man, look, my buddy Sean sent out the bat signal, and here I am. He made a liar out of me. So, happy liar stream. Thanks, Matt. Good to see you, buddy.
And Seller's like, I believe the Oklahoma City part.
you got Sean, you got chatters who are like, well, I didn't believe Trump sexually assaulted that woman until he corroborated it with that Hillary Clinton detail. Now that's a credible witness if I've ever heard of one.
Yes. Yeah, but just guys, just let it sit, because then people are like, "Oh, we read the It's like the aliens of the Simpsons, the aliens of the Simpsons. Oh, there's space dust on this. Oh, the guy's talking about Hillary in Oklahoma City. Okay.
Yeah, you gotta take this stuff slow. Every time something from the Epstein files comes out, there's going to be another story, and then it'll turn out to be, probably nothing 99 times out of 100. I mean, remember, I saw on X the other day, somebody was trying to make a big deal out of a photo of Trump with his daughter. They just redacted the face, and they were like, "Oh my God, look at this! It's not even in the Epstein files." So this is going to be a shit show.
Yes. All right, now, guys, we are moving on to here. This is United States Supreme Court, Donald John Trump versus Illinois, and it's on application for stay. Remember, guys, it's only for an application for stay, but it doesn't sound important, but it's actually very important. It came out today, certified hood single, certified hood classic. And it talks about federal immigration enforcement efforts have encountered significant resistance as well as some violence. And it's interesting they're noting that. They're noticing significant resistance as well as some violence. So even the SCOTUS is like, okay, it's not no big deal. It's not no big deal. They then go on, according to government, federal officers have been obstructed, threatened, and assaulted as they attempt to perform their duties. The government also alleges that an ICE enforcement facility in Broadview, Illinois, has been the site of frequent and sometimes violent protests damaging federal property, threatening the safety of federal officers. These attacks, the government says, have greatly impeded its efforts to enforce the immigration laws. And then it says on October 4th, 2025, the president called 300 members of the Illinois National Guard and active federal service, particularly in and around Chicago. The following day, members of the Texas National Guard were also federalized, it said Chicago. And it says, calling forth, the president relied on 10 U.S.C. 12406-3, which empowers him to federalize members of the Guard if he's unable with the regular forces to execute the laws of the United States. The United States District Court for Northern District of Illinois entered a temporary restraining order barring the federalization and deployment of the Guard in Illinois. The Seventh Circuit denied in relevant part the government's motion for a stay, permitting the Guard to remain federalized within Illinois, but maintaining the bar on deployment. So basically, they all sat around. Mm-hmm. The government asked this court to stay the district court's order. After the response and reply were filed, Justice Barrett, who is in charge of the Seventh Circuit, referred the application to the entire court. We directed the parties to file supplemental letter briefs on an issue the district court had addressed, but the parties' initial briefs had not. The meaning of the term regular forces in 12406, Section 3. They say in its supplemental brief, the government argues the term refers to civilian law enforcement, such as those employed by ICE and the Federal Protective Service. The respondents, echoing the district court, maintain the term refers to the regular forces of the United States military. And they say, we conclude the term regular forces likely refers to the regular forces of the United States military. Notice, they're like, we're saying, yeah, we think this is what they're likely refers.
Yeah, and that's because this is a stay.
Yes.
Right? It's an application for a stay. They're giving an order.
Yes.
A lot of these orders don't have any reasoning at all. They just they just tell you what to do. Here they're giving a little bit of reasoning, but it's not a fully reasoned opinion. So they use the word likely. They're giving themselves a little wiggle room to change their mind if they want to later, but it's pretty unlikely. If you got 6 members of the Supreme Court, as you did here, to sign off on that's what the term likely means, it's going to be pretty tough to change their mind down the road.
Yes. And they say this interpretation means the Call to Guardian Act of Federal Service under 12406. The president must be unable with the regular military, noting they're italicizing that so you understand, this is important, to execute the laws of the United States. And because the statute requires an assessment of the military's ability to execute the laws, it likely only applies when the military could legally execute the laws.
Before we keep going, can you pull up the statute again real quick?
Yes.
So if you were following what Sean was saying, if you go back to 3, so it says the president is unable with regular forces to execute the laws of the United States. If that's true, then the president can deploy the National Guard. But now according to the court, we now know that this means if the president is unable with the regular armed forces, with the military, to execute the laws of the United States. Well, now this creates a whole other can of worms because the president is not allowed to use the military to execute the laws of the United States per the Posse Comitatus Act, unless there's very narrow exceptions, right?
Yes.
So if the president is unable with regular forces, well, the president's not even able to use.
He's not allowed to legally.
Yeah, he's not allowed to use regular forces. So if you read regular forces that way, the law now basically says you can only use the National Guard if the military is unable to do it. But the military, you never even got to the part where you could use the military because you didn't invoke the Insurrection Act or other exceptions that might qualify for the Posse Comitatus Act. So this is basically dead letter, right? Like he would have to send in the military before he could send in the National Guard.
Yes. Okay, that's not working the way I wanted to do it. Dang. Oh, there we
go. It kind of just looks like you hate the troops, Sean, the way you're crossing out the word military with a red line. What's that all about?
I know, but that's basically what it's saying now, chat. It's with the military. That's basically what the Supreme Court just says there. So that's where we are. Actually, hold on. I'm going to try this again. There. We got to match it. We can't. We got to try to be proper here. There. Yeah, with the military. That is basically what they're saying. You have to use the military to make this happen.
Mm-hmm.
And it's like, I don't know about that. That's a little weird because, yes, the Posse Comitatus Act came about after the Civil War because of the issues of the military under Reconstruction was governing. You had military governors of these states. And the military was in charge of keeping law and order immediately after the war. Yeah. So it becomes an issue. And then, so talking about the Posse Comitatus Act.
Now, because the decision is, I don't want to derail you, we'll get into that, but because this is an unreasoned opinion, they don't give not a fully reasoned opinion. They gave us some reasoning.
They don't explain the contradictions.
Yeah, or they don't really explain, like, look, the government gave a brief and the states gave a brief about which meaning of the term regular forces was more convincing, right? And they said the states had a better argument. but they don't actually explain what the state said that was so convincing and what the government said that was not that convincing. So we're left guessing a little bit why they came out the way they did, and I'm sure we'll get into that. But that's the answer to the question. If somebody says like, what was so convincing? How did they come to this decision? We don't actually know.
Yeah.
We know that they did come to this decision, but the why of it is a little mysterious.
Yes, and they say ultimately, so the president can federalize the guard under 124063. He likely must have statutory constitutional authority to execute the laws with the regular military. And they point out that Congress can tell the president to do it because Congress, posse comitatus says, unless is authorized by Congress, you can't do this. And that's, once again, Congress's way of passing a law saying, until we tell you, you're not allowed to do that thing.
Well, and again, this is a big... The interplay between the statutes is really interesting because if subsection 3 meant regular forces in the broadest sense, if it meant ICE, if it meant blah, blah, if it meant FBI, right? Then subsection 3 might actually be an exception to the Posse Comitatus Act because Posse Comitatus says you can't use the military unless authorized by law. But subsection 3 says if you can't use regular forces, you can use the National Guard. So maybe that's an exception, right? Maybe that's an authorization from Congress.
Yes.
Right? But now we know that that's not what that means. So subsection 3 is not a circumstance expressly authorized by an act of Congress that would bypass the Posse Comitatus Act. So not only does it mean he can't invoke subsection 3 to bring the National Guard in, it means that it actually it further limits the use of the military because now he can't use that as a hook to get around Posse Comitatus for the National Guard in any other context. So it has some sweeping ramifications.
Yes. And that was part of the issue too, guys, is that like the Marines that were called up, yes, they were protecting the facility, but a couple times they were engaged in arresting people, which you're not allowed to do that. That becomes a Posse Comitatus issue. They're not allowed to be law enforcement. So, yes, Trump could call these people in to protect the building, but what is he going to have them do? Basically, all he could do is sit there and shoot like tear gas in the crowds from inside federal property. Like, they can't, as we've watched, nights while we're playing with models, like building models or whatever, they do that thing where they rush out and make the cordon and they start yanking people. The military can't take part in that. So there's a very limited thing they could do anyways, even if they can be used at all. And this is the Posse Comitatus Act, which also apparently you cannot use a space. You cannot use the people in charge of space to enforce the law. I know that they had to change it because technically they'd be to play. I think it's just funny. But yes, whoever accepting cases and under circumstances expressly authorized by the Constitution or Act of Congress willfully uses any part of the Army, Navy, the Marine Corps, the Air Force, or the Space Force as a Posse Comitatus or otherwise to execute the laws shall be fined under this title or imprisoned not more than 2 years or both. So this is the Posse Comitatus Act. It is an actual thing. It's an actual code.
Yeah, and there's a little nuance here that because it says you can't use the armed forces to execute the laws, the President Trump was very careful to say in all the briefs, look, I have inherent authority to protect federal buildings, but as Sean was saying, they're not out there executing the laws because executing the laws is a Posse Comitatus violation. But then you have execute the laws shows up in both statutes. So that kind of tees up an issue that comes down later where, the court disagrees, at least some members do, about whether those words should have the same meaning. But anyway, the point being, this is, while they use the word likely twice, and there's some wiggle room, while this is not a fully reasoned opinion, this is a pretty devastating ground to limit subsection 3 on. Because if they had said something like, look, we think the president is owed a lot of deference, but the actual standard is this, and we should review what the president says in light of this standard, right? Then they go back down to the court, and the president has a declaration of what the problem is, and the court applies the standard, and you keep fighting. Maybe you win, maybe you lose.
Yes.
This is kind of a headshot. Like you have to redo the entire legal thing.
And to be fair, when we've done these other stays, the Supreme Court saying based on these facts, you're not going to win. I mean, yes, the government has established they're likely to see it in the merits. That's their way of saying, yeah, they're likely to see it in the merits. But look, they're like the Supreme Court's like, look. If this comes to us and we had to rule on it right now, he wins based on what's in front of us. This is what they're saying based on this. We can't make that kind of ruling, but this is our way of telling you what it's probably going to be.
Yeah,
this is the best they can do without telling you ahead of time.
And someone in my chat just said this, and it's a very fair point. One of the things that's been, we've been kind of like quietly talking around in this context is that the president has not invoked the Insurrection Act. Yes. Now, if there is an insurrection, and if the president feels there's an insurrection, and if the president feels that the Insurrection Act is warranted to even invoking that changes the landscape of what kind of military force can be used completely. But that hasn't happened yet. Yeah. So when I say, it's a headshot to this theory, it is definitely a headshot to this theory. But that doesn't mean this issue is dead forever, but it does mean that it's going to substantially change.
Yes, this option does not work anymore, is basically what they're saying. And honestly, I mean, we'll talk about it later, but I have a theory about, I think they tried to go this way because they were worried about the Insurrection Act not working. And they would rather take the L here than on the Insurrection Act. Ultimately.
It's a really interesting mix, right? Because we have, we obviously have the 3 liberal justices, and then we have, Barrett and Roberts fully on board, and Kavanaugh on board but concurring, and he has some qualms about it, but he's on board. So it's a 6-3. The 6 is kind of a big deal to me, right? Yeah. Because like if it was a 5-4, like a true 5-4, then with Kavanaugh concurring, you think, oh well, maybe. They use the word likely a lot. Maybe there's some play in the joints. Maybe if we do a better job briefing, or if we find some new evidence, we could peel off Kavanaugh, and maybe it's different the next time around. But here with a 6-3, I think you're right, Sean. I think that the court's saying pretty clearly, if you come back with this same theory, we're going to shoot you down. Like there's no, you can't come back with this.
Hold on, chat. All right. This is, and we're, we really just need to start, and this is where the government's just fleshing, the court's fleshing out a little more here. At this preliminary stage, the government has failed to identify a source of authority, which is big. If, what's your enabling to do this? What gives you the authority to act this way? That will allow you to execute the law in Illinois. The president has not invoked a statute that provides an exception of the Posse Comitatus Act. Instead, he relies on inherent constitutional authority, which is, what you have to rely on if you don't have anything else, allows him to use the military to protect federal personnel and property. But the government also claims, consistent with the long-standing view of the executive branch, that performing such functions does not constitute executing the laws within the meaning of the Posse Comitatus Act. Now, notice they're pointing out that this isn't just him. This is them pointing out that this has been a long-standing view. So it's not just Trump coming up with this. I think the courts, which is interesting, the court's just pointing out that this is not just him coming up with this theory. And it's something that, they say, see the OLC letter from 1971. So this is not a new thing, really. Mm-hmm. I think that's important. Because you do, like, oh, Trump doing the norms, and it's like, no, he just had people who did a lot of work and they did a lot of research and found something from the unrest of the Vietnam War. When bombings and riots and protesting, like this happened previously, or there was support for it previously.
Well, and there almost has to be. If you can pull the Posse Comitatus Act up again, remember, chat, it says here, except in cases and under circumstances expressly authorized by the Constitution. Now, the president's inherent power to protect federal buildings is not expressly authorized by the Constitution. It's implicit, it's inherent, but it's not express. Now, could this statute strike down the Constitution? Obviously not. But like Sean's saying, the Congress and presidents have tried to read these things to avoid a constitutional clash between the Congress and the president, right? So what do the presidents say? They say, look, when we are protecting federal buildings, we're not executing the laws. We're not executing a law of Congress. We are simply using inherent authority. So the Posse Comitatus Act doesn't apply because that's not what we're doing. But as the court is pointing out, since 1971, they've been saying, at least 1971, they've been saying that protecting federal buildings is not executing the law. So now it's hard to say that protecting federal buildings is executing the law within the meaning of the National Guard authorization statute.
Mm-hmm. Yeah, and they point out, if this is correct, it's hard to see how performing those functions could constitute executing the laws. So they're pointing out, like, you can't have it both ways here. And that's their argument here, is that you can't have it both ways. And the argument is that if you're arguing you're executing the laws, well, that means law enforcement, and that means Posse Comitatus. So I think that's I think that's the way this, without having read this all the way, I assume that's where the Supreme Court's ultimately trying to get to this point, at least to them.
It's a little bit strange because.
Am I wrong, or is that kind of...
No. You basically read the whole thing. There's not much more to it. The dissents and concurrences are much lengthier. It's a little bit weird, though, because if you keep going, it says, thus, at least in this posture, the government has not carried its burden to show that Section 124063 permits the president to federalize the Guard in the exercise of his inherent authority to protect federal personal property in Illinois. So... again, if we can switch back to the statute, sorry, the other one, the National Guard statute this time.
Okay, sorry.
They've said execute the laws of the United States. Protecting federal buildings is not part of that, right? Because they're saying in the Posse Comitatus context, you said protecting federal buildings does not count that. So they've kind of now have a double whammy, right? They're saying Section 3 says if the president is unable to use the military, not the National Guard, to execute the laws of the United States, which does not include protecting federal buildings, then you can call it the National Guard. But if you with that gloss on this statute, there's no possible way, right? Like Trump has not invoked the military, and if he were to invoke the military, what would he invoke the military to do? It would be to protect federal buildings, because he can't use the military. He can't use the active military to enforce the law because that violates Posse Comitatus.
Yes.
Right. So, and he also can't call them in to protect the federal building. So the whole, basically, if he calls them in to protect the federal buildings, that wouldn't count under Section 3.
Yes.
Right. So even if he did call in the army to protect the federal building in Illinois, that still wouldn't get you any closer to invoking Section 3. So they've really cut it off the avenues in two ways.
Yes. And yeah, like I said, guys, this is, without having read all of it, yes, this is, if you're supporting this theory, then yes, this is, we got to come up with a new game plan. And so Justice Kavanaugh, Brewski Brett, concurs. So remember, guys, this is 6-3. And, maybe it's 5-4, but this really, Kavanaugh is basically saying, gun to my head, it's 6-3. So
now, before we do Kavanaugh, Sean, I just want to ask you,
yes,
because that's it. That's all the reasoning we get from the majority.
Yes.
Right? And obviously, Kavanaugh and the dissenters give more gloss, and Thomas and Alito write long, just as a warning that's coming. But like, what when you read the word regular forces, Like, what's your take on that? I mean, obviously, like, we're not scholars on this term, but like, does that strike you as the Supreme Court's right, or does that strike you like maybe they're pulling this out of nowhere?
I mean, I think you run into an issue here because, yeah, it's like, well, what if it can't use the regular forces? Then why, like, the interplay of this? It almost, so when you look at this, I mean, here's the Posse Comitatus Act. You cannot use, to execute the laws of the United States. Okay, well, if that's, like, if it gets to the point where you're calling out the military in the streets to suppress things, the idea that I need number 3 as an option seems kind of redundant, because if I'm to the point where Posse Comitatus is being invoked, we're at step 2. We're already here. If I can't execute, like, do you get what I'm looking at here?
Yeah, well, because look,
because if it's to the point where Posse Comitatus is getting invoked, things have fallen, like the world's gone sideways. Okay, well, when would the government invoke when would Congress allow me to use the military to enforce the law? Well, there's 2 times. I would be an invasion, and they'd say, look, we're going to have martial law because we got, like, the Russians are marching down I-95 right now. So we need, we're enforcing the law. Call up the guard. You're in charge of it all. Make it happen, Donnie. Or number 2, straight up rebellion. So if that's the case, number 3 is kind of redundant because I don't need this to execute. Like, it's surplusage.
Yeah, I think that's probably, if we go back to 12, the National Guard statute.
Yeah,
I think that's probably the most. Oh, that's Posse Comitatus. If you go back to the.
I'm sorry, I didn't switch back over. Sorry, yeah. Because if I'm dealing with this, it just says there are number 3 surplusage, because those are the only 2 times Congress is going to give me Posse Comitatus powers. Is if there's an invasion, or if there's a massive rebellion, which means, guess what? I can't execute the laws. So I don't know then, why does number 3 operate in this way?
It's also, it's hard to imagine a scenario where you're in like an active insurrection, let's say, and the Army and the Marines and the Air Force have already deployed, and then the president's like, well, those boys can't handle it.
Yeah,
we need the National Guard, right? Like,
yes, you're the guy running your pharmacy. It's like in Rambo. They need to call up the guy running the pharmacy to come go after we need to call everybody up,
Yeah.
Like, it's like, okay, at but yeah, that part of it's an issue too. Like, we've got big problems. Like, if the full-time soldiers can't do it, we're going to call up, the guys who do it like 1 weekend a month, 2 weeks a year.
So I do think you're right that this interpretation makes subsection 3, if not technically surplusage, almost vestigial. Like, the circumstances where 3 would apply, where 2 doesn't apply, seem vanishing, if not zero, right?
Yeah.
I think,
and it's weird because number 3 in this statute was written way after Posse Comitatus.
Yeah.
So I think it's clear that they weren't, this is, I think regular forces means like the government, like just in general. Because the idea is I can't, if I can't, at some point it's like, but I also run to the issue of, if I call up the National Guard and they're now federalized, you run, like I said, the idea of like they're guarding the facility, and okay, they're going to arrest people every once in a while. Like, I can see that being an issue, but I could also see them arguing suppressing an unruly crowd is law enforcement. I mean, technically, like, riot control is a law enforcement capability. And you are, enforcing the law. You are dispersing protesters. So I can understand that to an extent. I kind of understand regular forces, but once again, I'm like, it's kind of torn because I don't know if this is the best interpretation at that point.
So I think this is probably one of the better arguments for Team Trump on this. And I will candidly admit I've not studied the letter briefs. I kind of skimmed them, but I think the argument on the other side, if I'm going to steelman it, is that regular forces, forces is often used to describe the military.
Yeah, they're the armed forces.
The armed forces. So like forces normally means military. Regular normally means as opposed to reserves.
Yes.
Like, right?
Yes,
and the National Guard are a reserve force. Yeah. So like, I think there is a kind of like, what I'm not in the weeds on, I'm sure they provided like all the examples of where Congress said regular forces 100,000 times, right?
Yes.
And I should probably pull some of them and see what I think.
No, and I agree. These are two separate words with very, depending on how they're used, very important meanings.
Yeah. So I think that is probably why the Supreme Court was sensitive to this, is that like the phrase regular forces.
I mean, and to be fair, like Title 10 literally says armed forces.
Armed forces, yeah.
So, and what's part of the armed forces? General military law, the Army, the Navy, Marine Corps, the Air Force, Space Force, reserve components, and then alternative military personnel systems. So you go to subtitle E, what's part of the armed forces, and it says reserve components, so it's part of the forces. But it says reserve components, and then you get to their organization, administration, personnel generally, promotion, retention, training, and reserve. And it's actually very interesting. The U.S. military is actually like the Army itself is like actually a bunch of different organizations. Really, it's kind of interesting how officers are commissioned in reality. But you get, you go through here. These are all the different things. So it's, how is this set up? What exactly are we doing here?
Yeah, I was kind of skimming through the letter brief, and they pointed to another part of chapter 10 USC 101, where it says the term regular with respect to an enlistment, appointment, grade, or office means enlistment, appointment, grade, or office in a regular component of an armed force. Right? So like the phrase regular is often used to modify force, and it doesn't it's definitely not referring to the FBI or ICE or the CIA, right? It's referring specifically to the armed forces.
And chat, if you're ever not sure when you're reading a section of a law and you're not sure what do I do, well, go to the first part, because there should be definitions. If there aren't, well, then you're having a bit of a problem here. But the general definitions, what are they? Okay, well, what are the definitions here? So like, what does the term United States mean? It means the states in the District of Columbia. And you're like, okay, well, what does all this mean here? Yes, so the armed forces, what are they and how do they work?
Yeah.
And also, if you weren't aware, guys, the Public Health Service is an arm of the armed forces.
That's so weird.
Uniformed service. Also, NOAA is as well. Yeah, so like Public Health Service, you get a commission. Yeah, it's pretty interesting.
But I mean, if you even there, like, see how they separated armed forces from unified services
or uniformed services. Yeah.
Now, I guess you could make the argument they didn't use the phrase armed forces; they used the phrase forces and then regular forces. But I do think there's some meat on the bone here in terms of the definition. Like it does.
I think there's. I'm not saying there's not. Like I just told you, I think there's a problem, because if I want to put the military out there to just having guys sitting up on top of the Portland building, just ka-chunk, lobbing tear gas and rubber bullets at the protesters. Technically, riot dispersal is a law enforcement thing. That's why in the military, they're trained to do like, military police are trained to do like the crowd control and stuff like that. It'd be available to do those things. But that's more of a law enforcement, not a war fighting capability. So like, I understand part of that argument, how this all works.
And then what they cited was B12, which is coming up.
Yeah, B12 here. Okay, yeah. The term regular means the regular components, which means the active duty.
Yeah. So if the term regular means active duty, and then forces has kind of this kind of like plain meaning of the armed forces, then you could see how they'd read it as saying, oh, so not the reserves, i.e. not the National Guard.
I mean, James Douglas brings up a great point. It was nationalizing the Guard to end the segregation of Southern schools illegal. I mean, based on this, you might have an argument it was. Because he wasn't able to execute the laws, so he called in the military.
What I don't know, and maybe James does.
Well, so the way it worked was
if the state calls the National Guard.
Well, the state called the National. So Governor Fabus called up the National Guard in Arkansas, and he said, "You're not to let any black kids into the school because marshals were going to escort him in." So the National Guard was ordered up, and he called them up, and they deployed. And under the governor's orders, they stood guard out front, saying, "You're not allowed in." Eisenhower federalized the National Guard and said, "You report back to your barracks and stand to in your barracks." So the National Guard went back to their barracks and they sat on their, sat around, and the 101st Airborne Division came in and escorted them in. Yes, I bet he said different words than "no black kids in my schools," but that's what happened. Then the 101st Airborne Division came in with bayonets and, as the pictures show, forcibly integrated the schools. I mean, depending exactly, yeah.
That's interesting.
I mean, it's kind of an issue. How does that work? Because he couldn't enforce the laws of the regular forces. The marshals couldn't do it. So are we arguing that was an insurrection? Although I think there would be the Congress and the Supreme Court at the time would have argued that is an insurrection. It was an insurrection they could have put down, but it wasn't declared an insurrection.
If the state used the National Guard to thwart federal policy, they
So for example, if Jared Polis calls up the Colorado National Guard to stop ICE from acting, if he made him put a cordon around the ICE facility in Denver.
I mean, actually, no. Now that you're describing it like that, that almost seems. I mean, I never really deep dove the phrase insurrection within the meaning of the Insurrection Act, so I'm not giving a reasoned legal view here. But in terms of the colloquial meaning, if a state brought out military to thwart the federal government, that almost seems definitionally insurrectional.
Yes.
If that's not insurrection, what is an insurrection?
Yeah, but I mean, based on just what we're reading here, but to be fair, that was 1954. Well, what year was Little Rock?
Oh, that's a good point. The law might have been totally different back then.
Because this was the Posse Comitatus Act, last amended my birthday in 1956. So, based on my birthday at least, Little Rock integration crisis, 1957. Oh, I thought it was prior to that. Oof. The Little Rock 9, that was 1957. So, yeah, I don't know. Technically, it sounds like Eisenhower may have done something illegal. They violated the Constitution to do integration, chat. Yeah. So it was all illegal.
Though the National Guard call up was 94, so that's a lot more recent.
The National Guard. What do you mean National Guard call up?
10 USC 12406.
Oh yes. Yeah, that was a reorganization of things.
Yeah.
But no, I'm just saying here. It sounds like Eisenhower technically violated the law because Congress didn't give him special dispensation to do it.
That's interesting. Yeah.
I mean, you heard it here, chat.
I don't
Little
know.
Rock 9 were ultra furious.
I don't know if he invoked anything. We'd have to look at the record. But it's funny though, because
yes, we would have to.
It's always this strange game where after the fact you look at the things the president said and was like, I think maybe he invoked this law. And it's like, okay, well, he didn't say that, but we're gonna play this game afterwards and try to make it work.
Yeah, and back then he probably just said, "Get those goddamn kids into school. I don't care how you do it." I'm sure that was more of there wasn't necessarily a lawyer standing around saying, and actually he issued an executive order. Oh, okay. Here we go. He did executive order 10730. Wow. Okay. So he says, where is okay. There are individual and unlawful assemblages, combinations, conspiracies, and willful obstructing the enforcement of the orders of the Eastern District of Arkansas, respect to matters of Central High School in Little Rock, Arkansas. It such willfully hinders the executional laws of the state and of the United States, making it impracticable. It sounds like he had trouble executing the laws of the United States.
Sure does.
I don't think he had regular forces. Oh, well, actually, to be fair, I think he is. I think he would argue I used the military to do it, so I did use the regular forces. I wonder if that's how he would. Actually, it's probably what he would argue. Sorry, chat. I thought we were going to have an own Dizzle here, but no, we don't. He is going to argue. He would argue probably I used the military to enforce the law, but he federalized them, and it's like I don't know if you could technically. So under Chapter 15, Title 10 of the United States Code. And what is he? So what is that?
Yeah, because 332 is a rebellion statute.
Yeah. So So here we go. It doesn't work that way.
So he actually said that was a rebellion.
Yeah, but I don't know if it's. Is he arguing it's? But he doesn't. Well, he might be able to argue that's the rebellion. I don't know if that would work that way. Oh, hold on. We need to go back here. So he says, I hereby authorize Secretary of Defense. Title. Yeah, here we go. We'll open this up here, chat, while we're here.
Yes, 332, 33, and 34.
Yeah, 330.
I know 32 is a rebellion provision.
Yeah, so hold on. Here we go. 332. Well, actually, this is. He's citing delegations of government initially. Huh. Let's see here. Let's go back. Yeah, Section 1, Title 3 of the 301 of Title 3 of the United States Code. That's not rebellion. This is, this is just the designation, authorization, and delegation of functions. So he's just arguing some basic. So it's just he's just arguing I have delegation to do it. Hereby authorize and direct the Secretary of Defense to order an active military service appropriate to carry out the purpose of this order, any and all units of the United States Guard within the state of Arkansas to serve in the active military for an indefinite period and be relieved. I think he would argue also, though, he didn't have them do anything and sit around on their ass. So they're not necessarily engaging in law enforcement, but still. Assuring that all orders of the United States District Court for the removal of obstruction of justice is authorized. He says in furtherance, the Secretary is authorized to use such of the armed forces of the United States he may deem necessary. Okay. He's authorized to delegate the Secretary of the Army any authority conferred to him by this order. Okay. Well, that's not really. He could confer order information onto people if he wants to. That's not really an issue there. That's interesting.
I muted myself. 10 U.S.C. 332, what I'm finding is that whenever the president considers that unlawful obstructions, combinations, assemblages, or rebellion against the authority of the United States make it impractical to enforce the laws of the United States in any state or territory by the ordinary course of judicial proceedings, he may call into federal service such of the militia of any state and use the armed forces as he considers necessary to enforce those laws or suppress the rebellion. I'm not familiar with this law.
No, it's not. But here's the thing. If you Google it, otherwise it doesn't necessarily show up right away. But so when the president considers unlawful obstructions, combinations, assemblages, or rebellion. So unlawful obstructions. Okay, well, this is basically, this doesn't work. Can't do it. This is all removed based upon the Supreme Court's ruling. Those don't work anymore. Those are illegal. Can only be rebellion because you can't use it for any other purpose.
Yeah, I've never.
We're gutting. They're gutting different things here by doing this. It's like, well, okay. What about this statute? What about this statute? Like these start running into problems very quickly here. I just like.
Well,
I don't know if we properly planned this one out here.
what I'm generally confused about is
Yeah.
if 10 USC 332
Well,
exists,
it's been changed
why do
now.
you need the national? Is it
This moved into 10 USC 252.
Oh, okay.
I think there's been some reorganization here. It got renumbered in 2016. But yeah,
but it's still good law.
Yeah, it's still good law. It's still good law.
So then what does he need the National Guard call-ups provision for? Like, why not just use this?
I don't know, but based on the Supreme Court doing this unlawful obstructions, can't cite that. Combinations, nope. Assemblages, nope. It's got to be rebellion.
Well,
because otherwise, posse comitatus.
But posse comitatus says that if you have an express act of Congress, you're allowed to.
I guess here's what I'm saying. I'm not that smart, and I really hope to God the people in the DOJ didn't run around and not consider this issue.
Yeah, no. I'm sure they did. I just don't.
Yeah, what are we
I've never
missing
read
that
this
they
law
didn't get?
before, and my first reaction to reading this is, if this exists, why are we talking about this dinky National Guard provision? So there's got to be something in here. Rebellion against the authority of the United States.
Or rebellion against the authority of the United States, make it impracticable to enforce the laws of the United States by the ordinary course of judicial proceedings. Okay, so if a court orders you to do something, you may call in the federal service and militia of any state. Okay, well, there's your exception to posse comitatus. There you go. So there's your exception. That's one of these. This is one of the express circumstances.
Maybe the only thing I can think of, and again, I apologize for the speculation because I've just never seen this law before. Maybe there's some court case that says that particular law requires some level of exigent circumstances that are, like that. It really requires a rebellion.
I don't think that's what they're getting at. They're just saying if you can't enforce a court order, here you go. I don't think it just says unlawful obstructions. That could basically mean, what's an unlawful obstruction? What's a combination, or what's an assemblage? That's very broad.
Do you think maybe it's the court order part where they're like, ICE doesn't have a specific court order? They're like looking to pick people up. They don't.
No, I think it's more of like the Supreme Court says you can do this. I don't think this is the ordinary course of judicial proceedings, meaning like the Seventh Circuit said, go forth and sin no more, my son. That's what they're getting at. So in this case, the Supreme Court said integrate the schools, and the Eastern District of Arkansas said integrate the schools.
Oh, I see.
There you go. And this is like I said, this is one of those express proceedings. So there you go. Eisenhower did not violate posse comitatus, chat. He's just guilty of murdering the bonus army workers as MacArthur's aide de camp. So that's different.
He's lucky to have us as lawyers. We worked through it for him.
There we go. Yes. We worked it out in real time. We had to read the law and figure this out. So, by the way, he actually did do that. He was MacArthur's aide de camp when MacArthur broke up the bonus army. Although, to be fair, the bonus army is trying to extort Congress. So, all right. So, did we kind of answer some questions? Or I think we did. I think I learned something today. I hope you guys did on that. So, there are some things that happen here. Now, should we start with Kavanaugh, or where should we go from here?
Kavanaugh.
I haven't read it yet.
Kavanaugh is mercifully short, so that's probably a good one to go to.
Okay, so I think we can skip this part. This is fluff here. He says to federalize the Guard, according to him, he must determine that he is and he's important because if he's the waffler, if this is what he's stating, that means they're all okay with what he's saying. That he is unable with the regular forces to execute the laws of the United States. Okay.
Yep.
In my view, the statutory and regular forces likely refers to the U.S. military, not civilian federal law enforcement. Once again, I think that makes it completely superfluous at that point.
But in terms of court politics, it means while he's concurring, he agrees with the majority on this point. So it is a real 6-3 on that point.
Yes. But he's saying on the current record, however, it does not appear the president has yet made the statutorily required determination. He is unable with the U.S. military as distinct from federal civilian law enforcement to ensure the execution of laws in Illinois. And he says the president, of course, would have great discretion to make that determination, as the state itself acknowledges.
Now, I'm going to be honest. and I deeply respect Justice Kavanaugh. I think he's wrong here. Like,
I mean, if he has that determination, then all he has to do is say it, and therefore it's done.
well, that's what I mean. Can am I able to share screen? I don't know if I can here.
No, well, yeah. Hold on here. Yeah,
I might be able to.
Well, if you share it down here, I can grab it. Yeah. Okay. Oh, hold on. I gotta remove this. There we go. Add a stage.
So this
zoom in.
Oh, this is a memo to the Secretary of War, the Attorney General, and the Secretary of Homeland Security from October 4th, 2025, signed by Donald Trump. And if you look at what he says in here, he says the members of Illinois National Guard called to federal service shall protect ICE, FPS, and other United States government personnel who are executing federal law.
Right. And if you could zoom in a little more, some people are.
Is that better?
Yeah, there you go.
Okay. Federal property in the state of Illinois, they shall do so at any locations at which violent demonstrations prevent the execution of federal law or are likely to prevent the execution of federal law based on current threat assessments. So, I mean, maybe that wasn't enough of a declaration that federal law, there's a problem enforcing federal law by the president for Justice Kavanaugh. But I mean, it's not like that's nothing. Like, the president clearly had subsection 3 in mind. And to me, this reads like you're saying, I'm concerned that we cannot execute federal law. Now, to Kavanaugh's credit, maybe what he's saying is this kind of says, like, I want to deploy you and you're going to be there. And then if we find out in the future that we can't execute the law, then you can move in, as opposed to saying, I determined that we already are prevented. So maybe it's a little too future tense.
Well, I think, at which violent demonstrations prevent. They shall do so. But to be fair, though, they can't go back and do the things that have already been done. So I get his argument at that point. But I just think this is a bit of a cop-out by Kavanaugh. It's like, because it's almost like, how much does he have to say? And are we now almost getting to the theory, which I don't agree the president has the right to say, it's unreviewable? Because as long as he articulates a theory, are they saying we can't review it?
I mean, that's the thing, right? Like,
because the court never usually does that.
It almost feels like Kavanaugh's applying a magic words test, right? Because, like, certainly the president was talking about violent demonstrations preventing the execution of federal law. Now, I do think there's a good faith argument you could make that this isn't sufficient because the president didn't say, I declare that in my assessment, we currently cannot enforce federal law, and therefore. So, I mean, I get that, but it's a little, certainly this is at least good evidence that the president made such a declaration.
Yeah, and I hate this idea you have to say magic words, because that's not what the law is meant to be.
Yeah.
Like, the idea, like, you have to say, oh, you didn't say hocus pocus before you did. It's like, that like, that's not what this is meant to be for.
Now, if I'm giving, okay, let me put on my, like, Kavanaugh hat and try to be, like, really credible here. We looked at what Eisenhower did, right? That declaration where he cited the laws, he cited the provisions, it had the whereas, wherefores. That was a lot of a cleaner legal declaration of intent. Yeah. So, I mean, if Kavanaugh is saying, I need a document like that, like, I don't need a memo to your underlings. I need a legal documentation in which you declare that you cannot execute the laws and therefore you're invoking the following provisions. Maybe that's what he means. So let's keep looking at what he says, because when I read this, I was struck. Like, I know the president said something about this. Maybe it's just not enough for him.
I think that's I don't. But I mean, here's the thing: even if he says that, it's 5-4 then, because you still got if Kavanaugh's getting wooed over, I don't see. Is he going to get Barrett or Roberts to go along with him?
Well, and keep in mind that he cares about this because he wanted to have a narrow ruling.
Yes.
But what we'll see now is what he wanted to do is say,
Yes.
The declaration was insufficient. So
Yes.
we don't have to reach regular forces.
Mhm.
We don't have to reach anything else. We just say the declaration's
Yeah.
insufficient, send it back down.
Yes.
Right?
Yes.
So he would have had an opinion that would have said, no, Trump loses. If Kavanaugh was the majority, his opinion would have said Trump loses, but on this narrow ground of having an
Yes.
insufficient declaration,
Yes.
which if Trump believes that he cannot enforce the laws, he could easily cure by simply making a declaration, right? So it would be a much smaller opinion if Kavanaugh had his way.
Okay. Chat. Sorry. Also, somebody sent me some I gotta show them. I'll grab them when I get a chance. But I got a couple of stickers in the mail from Amazon chat. Who sent those? Because it didn't say who sent them. I'll show them tomorrow when we're hanging out. But trying to figure that out. No, it didn't come with a note.
Trust your chatters opening their mail. You know, they're
yes. Well, it came from Amazon. It came from Amazon. So.
Oh, okay. I was gonna say I got a bunch of Oklahoma City fans in here. If you know what I mean.
Yeah. No, I trust me. I give them the Ace Ventura treatment at the beginning, and because if it goes off, I want it to go off. I don't want to have to go to work in the morning. So.
Yeah, Jefferson, thank you so much, man. And yeah, where it has to say, whereas the National Guard is bigly needed. That's the key. Yeah, I mean, I think if they'd done that, they would have solved the whole thing.
But here's the thing: I think Kavanaugh doesn't say concurring in part, dissenting in part. He just says concurring.
That's what I mean. He wanted to rule narrowly, but he's not. This is a 6-3. He's not like a sneaky 4.
No, yeah, and he says the court goes further. He says it starts by concluding regular force means U.S. military. He says, as noted above, I agree with that initial point. So, as much as he's saying, well, I don't really want to go that far, you are going that far. And he says, from there, however, it conducts a complicated and debatable statutory analysis. The court says that under the government's argument, it's hard to see how performing those functions, protecting federal property, could execute the laws, under the laws. He said, on that premise, the court further states that at least this posture, the government has not carried its burden. Okay. And it says that he's unable with the U.S. military to prevent federal personnel and property from harm.
Now, this is an interesting point that Kavanaugh's making that I kind of agree with. Yeah. Now, I haven't, again, this is very new to us, so we haven't had time to really sit with this. But if regular forces means active military, why did they have to go further and make all that additional ruling about but if you're protecting, that also doesn't count as executing the laws and therefore it doesn't add up? Couldn't they just have said like that's enough to dispose of the case and therefore we're done? Yes.
And real quick, Kathy, I see you're leaving. Kathy, guys, remember you're a realtor in New Jersey, not the Channel Island of Jersey. Looking to buy, sell, rent, do a fee tail subject to complete divestment. Ryan gets that joke. Get a hold of Kathy. Says, do I agree with the Supreme Court? No, because I feel like, as I'm stating, they by their ruling have removed Section 3 as being an effective statutory option. Because I understand partially how this works, but with the interplay into actually applying the statute, it only turns you into 2 options, meaning rebellion and invasion, no Part 3, because Part 3, rebellion or evasion means Part 3 can't happen by function or implication. So I don't know how that would work. But thank you, Kath. Thank you, Kathy. Thank you for the super chat. I appreciate it. So, but yes, good night to all. Merry Christmas. Yes.
Merry, Kathy.
Yeah, sorry, Ryan. I just wanted to get that there.
No, of course.
But yes, the statute also separately authorizes the president to federalize the guard if there's an invasion or rebellion. And I think Kavanaugh's pointing out, I think he's bringing up the argument I am, how does that all work then with these 2 parts?
Well, and I think this is one of the questions that certainly...
It sounds like Kavanaugh's thinking about what I'm thinking about.
Certainly the main dissenters have make a huge issue out of this. And they say some stuff I disagree with, but one of the questions that the court always has is how broadly do they rule? because they have a lot of discretion. They can rule about everything. They can rule about the one thing to decide the case and stay super narrow. And the majority did go broader than they arguably had to. I don't know why the execute the laws analysis was necessary to decide this case, which is interesting.
Well, it makes me feel better if I'm on the same wavelength as Alito and Thomas, because like I said, I haven't read it. I've just seen a couple of tweets and that was it.
Yeah, Alito and Thomas are not happy.
I'm live reacting here, chat, so don't worry, we're going against again. He says, the court's legal interpretation, and I understand it, could lead to potentially significant implications for future crises that we cannot now foresee. Yeah, and that's the problem when you make sweeping rulings like, well, what about this? And now you have to go, oh, shit, now we have to deal with this. Can we override part of our ruling? Because then it makes the court look, it undermines the court's authority. And he says, consider hypothetical. Okay, well, maybe this is answering my question. Suppose a mob rapidly gathers outside the U.S. courthouse in Philadelphia in response to an unpopular decision or to influence the outcome of a pending matter. This is a stab at all the fucking protesters right there.
Yeah. Or the one who, like, tried to assassinate him.
Yeah. This is a stab at that. Suppose that mob is threatening to storm the courthouse and attack the federal judges, which has happened.
Mm-hmm.
You know, and to damage or burn down the building, thereby preventing the execution of federal law, which sounds like Portland, Oregon in 2020. And he says, suppose further the U.S. forces cannot readily mobilize or deploy to the site in time. Maybe all of the Oregon National Guard has been deployed already.
Yeah, or you know, like, look, if regular forces means military and you have to deploy the army first, like the army might not be near this city.
It's in Ohio. There's no active military base in Ohio.
They might all be in Venezuela for all we know.
Yeah, but I'm just saying, if, like, let's say here in Cleveland, Ohio, there's no army base nearby. Yeah. There's an Air Guard unit out in Toledo. There's a Coast Guard, station in Cleveland, but that's it. There's no active army installation. And he says, suppose further the U.S. military forces cannot readily mobilize to deploy to the site in time, which, we just can't do it fast enough. And that the local police and federal security forces are outnumbered, and the president wants to federalize the National Guard to protect the courthouse. Says, under the court's order today, even in those circumstances, the president could not do it. And he says, and this is important because let's say the president doesn't want to declare it a rebellion. He wants to do it as lightly as possible because declaring it a rebellion might make things spiral out of control and make it worse. He shouldn't have to declare it. Like, no, you have to declare martial law. It's like, that's actually bad. We want to limit the government's power and use of that power and how much it's damaging.
I almost think that, because the hypo is interesting, but part of me thinks that he wrote the hypo as an excuse to add footnote 2. Because now he said, like, look, in footnote 2, he says, this does not address the Insurrection Act.
Yeah.
It does not address or purport to disturb the president's long asserted Article 2 authority to U.S. military, as distinct from the National Guard, to protect federal personnel and property. So to your point, because that's how he reads the opinion, and I think he's right, it doesn't address those things. The one weird outcome of this opinion is, let's say the president is worried that they're going to burn down the courthouse. Yeah. Under this opinion, he should send in the Marines.
Yeah. Do you want the president sending the 82nd Airborne in every time there's a problem? Well, do you want, and this is, once again, this is where we get to this. If you want this to happen, are you sure, are you sure about that?
And the main opinion did say that protecting federal buildings is not executing the laws within the means of...
Okay, so it's commander-in-chief by protecting federal property.
As said. So that's not that, like, if sending in the Marines to guard a federal building, I don't think would be a posse comitatus violation.
Yeah, but everybody was shitting their pants and pissing themselves about it. So, well, wait, you told me I couldn't do that. Wait, so you're saying that isn't posse comitatus? Like, wait, I thought, like, you guys we can't have it both ways here. We can't have it both ways.
Yeah, so that's the odd thing is that this ruling might tee up that Trump uses the Insurrection Act, but it also might tee up that Trump just sends in, the Marines to guard the ICE facility, which arguably would be, like kind of from a, we don't really want to have military patrolling.
Do you want to see the 75th Ranger Regiment fast roping out of a Black Hawk helicopter onto the roof of an ICE facility under protest? Like you guys piss and shit about troops on the streets. Well, you told him, we don't want him to put troops on the streets, but now you're telling him you can only put troops on the streets.
Yeah.
So it's like, you're kind of like, you're like, no, Orange Man, don't do that. But you're only telling him that's all he can do.
So I think what Kavanaugh's raising here.
This would be atrocious optics, though. God.
Oh, God, yeah.
Sending in like an active duty military unit like that. Whoa. I don't even care if it's a military police battalion. Like any active duty unit like that. Oh, my God. Yeah.
Well, and I think this is something that Kavanaugh is right to raise, which is that, doing the extra bits, and making this opinion broader than maybe it had to be will have collateral consequences, which can be tough to identify sitting here today. Yeah. Like, is his hyperbole? I don't know. Like, hopefully that never happens, but certainly it does seem like it could lead to military deployment, which would be kind of like a perverse outcome.
I mean, if we're going to play this game, enforcing the laws of the United States, he's authorized to protect federal property under federal law. So he's authorized to enforce the laws of the United States. He now has a judicial proceeding supporting him. Mm-hmm. Is this what we want? And no, the Supreme Court's got to be like, no, not like that. It's like, but what do you mean then? I mean, this is where...
And remember, I do think that Barrett's opinion, I assume she wrote it, even though it doesn't say her name.
Yeah. You think she wrote this, the main opinion, or the main part?
It's her or Roberts, I would bet.
Yeah, I probably is one of them.
Yeah. I say that this is like naked judicial realism.
Sure.
But I think the three liberal justices were easy votes to get. And Barrett and Roberts were probably trickier, closer calls. So you would basically need their imprimatur to get the opinion written.
Oh yeah, no, they had to approve it. They had to approve it. But I mean, here's the point. This professor,
Hold on. One of your chatters listens to a lot of oral argument. Not enough I don't understand to be KBJ.
Yes. Yes.
I was just laughing about this the other day. I've never heard a justice say I don't understand as often as she does.
No, some of those were great. And the one we're gonna listen to here coming up is the case that just came up about what's the IQ threshold for executing people. That case just got argued last week. I hadn't had a chance to listen to it yet, but I do want to hear it. But I'm sure she's like, I don't understand when you're discussing how stupid people have to be. I'm like, I'm sure that's going to sound like she's going to fit right in. Like,
maybe I'll just say that she has a distinct speaking and writing style that does not seem evident in this opinion.
From now on, we're going to have an I don't understand counter. No compromise.
Okay, so but I think this is a point well taken. I think this is a good point that Kavanaugh raised. That this is a potential perverse consequence of this ruling.
Yeah, great. Using the military, using the National Guard to make sure that they're not fucking with the building. Okay, well, here's Delta Force now patrolling it. Have fun. It's like I don't want that. I would rather have the National Guard doing it, but this is what you want. And he says, although that kind of scenario doesn't arise, Trump could say, I'm curing cancer tomorrow, and people would probably want to burn down the White House. The poor oncology doctors.
Well, it's a thing, though. Like this the provisions where you call them the National Guard are supposed to be rare. So like the hypothetical he described is rare, but that doesn't mean, it's for those specific. Holy shit, that's a really funny account. Oh,
yeah,
that's really good. That's
really
good.
No,
well
Justice KBJ shows up all the time when we listen to SCOTUS. But it's rare. But this is happening. Like, this is kind of one of those things where I was commenting on this. The idea that Trump is not a conservative president. He's the only president that's ever actually enforced border security. Like, every time we hear about all these border, gangs of 8 and all these, we're going to have pathways to citizenship, and part of that includes sealing the border. Guess what he did? He sealed the motherfucking border. Like, he's doing step 1 of immigration reform. Like, he's doing the thing that none of these Republicans ever had balls to do. So it's, this idea it's going to be rare. Yes, somebody who's actually going all out to do this.
Yeah, he's not economically conservative.
Sure.
But he's conservative in a lot of other ways, and he's just kind of he's a very new breed. I think the border's a good point, and the other thing is that he's actually dismantling the administrative state.
Trying to, yeah.
Well, he's trying, but I mean, saying he's making some progress. Like that. A lot of people have talked about doing it, but they've never done it. Like I saw a graph recently that just, I'm sorry if any of you lost your jobs. I don't mean you particularly, but warmed my heart, where they're showing the graph of federal employees since Trump took office. And it's just this straight line down. It's like, good, fantastic. That's great.
And Phil Kogan's great. Yes. These are the same people who were shitting themselves over the idea of Trump using Dev Group, because we use the real correct names for these units, using SEAL Team 6 to go kill political opponents and being immune from the laws. Yes. These are the same people who were terrified at that prospect. He needs to use the military. This is a good thing. It's like,
well, to be fair, if he uses the military to protect the building, they're going to have a problem with that too.
Yeah. Oh, I think so. Yeah. But at that point, then, if they're going to, if he does that and the Supreme Court steps in there too, it's like, well, you said I had to use the regular forces first. So then they're going to have to then admit, well, yeah, Section 3 actually doesn't exist anymore. You have to declare a rebellion.
Which I think that's where this is going, right? Like, I think they're basically saying, like, you have to declare an insurrection or rebellion in order to do what you're doing.
Yes.
That seems to be where it's going.
Yeah. So,
all right, so he's not much longer, I think, if I recall correctly.
Yeah, and he says, hold on here, but the potential consequences combined with the novelty and difficulty of statutory issues addressed by the court underscore why I would not opine more broadly than necessary to resolve the application. And his comment here, he says the decision only reflects on likely conclusions that comes out of preliminary stage. But this is pretty much where they're going to be, because it's really hard to reverse at this point. It's really hard to reverse. You can't really change it up too much.
I mean, yes, the court said likely. So, later they could go, oh, well, you changed our mind. But, probably not. These are judges. They've probably figured out what they think the law means. But, yeah, I think his point that I'm sensitive to is if it's just an injunction and you're doing it on a preliminary basis without a fully reasoned opinion, why not be as narrow as possible?
Yes. And he says, they can try to fix it, but it's they got hit with the torpedo, guys. This is not like, oh, we bumped into a coral reef. No, like a torpedo just ripped open the side, and like you can't say, oh, we can keep the ship afloat. You're gonna have to probably get into a new boat.
Yeah, like I was saying before, like I thought he might lose, but originally before the court asked for supplemental briefing on this issue, we thought it was going to be a question of, was the declaration sufficient? Was, how much deference is owed to the president? Those are much more like, they're not torpedo issues. Those are more like knife fight issues. This is just blows a hole in the theory completely.
Yeah, as I put in the chat in the title, this is the Christmas Cope session chat. Here's how Trump could still win. And he says, before addressing these challenging and far-reaching questions at this stage, I would have at least invited further briefing and possibly also held oral argument. Yeah, but you really probably wouldn't have changed your mind at all. On the application itself, or by granting certiorari before judgment, akin to what the court has done on other cases like Trump v. Casa, Ohio v. EPA, and a couple others.
Well, I mean, look, just decoding this for the audience, he's just saying, like, this is kind of a big deal. Like, this law has never been interpreted by the Supreme Court before. This is the first interpretation, and it's being done without the benefit of, like, the full briefing schedule, without the benefit of full oral argument, without the requirement of writing a fully reasoned opinion. So, given that we're talking about national security, and given that we're talking about weighty constitutional issues about, the president's duty to defend the country versus, Congress's obligation to keep the president from imposing martial law unnecessarily. These are high stakes issues. Maybe we should be slow and careful rather than being quick.
Yes. And he says, I've stated with previous interim applications substantial important difficulty. The court can help guard against mistakes or misjudgments by employing additional process when time is available. And to be fair, it's the wintertime. Things have died down. And I think part of the issues here are probably next spring enforcement will pick up again, but it's the middle of winter. You're not going to wait. That's kind of a waste of time to do all this. But also you're going to have decreased civilian activity outside of, nobody likes protesting in the winter, especially in Chicago. So I think that and it's already kind of tapered off in LA. It's pretty much tapered off. In Portland, it's kind of tapered down again. So I think there's some, we'll come back another day.
Well, and also keep in mind that he would have sent it back down and said, you lose on a narrow ground, that your declaration was insufficient. Now, again, I'm not sure. I think he was reaching. Candidly, we looked at the document.
Yes.
But now I think we understand why he was reaching. Because he's saying, look, if it's winter, if I send it back down and we just say the declaration wasn't good enough, right? Then they can keep litigating. National Guard stayed. There's no melting ice cube. There's no emergency. There's no risk of tyranny. It's already stayed. So we just let that play out, right? And we let the case develop, and we do it all in due course. I think he was reaching for a way to get there, but I understand why he thought that would be a better outcome, if that makes sense.
Yes. And he says, no, on some I vote tonight the application, but do so on narrow grounds. Yeah, but your narrow ground, this is already a very narrowly grounded issue to start with. So, we're already on a tightrope at this point. So I don't know how much more narrow it gets. I would not reach the broader statutory issues addressed by the court.
Yeah, I wish he had found a more compelling narrow ground that would have gotten more votes. But the problem is his narrow ground, I think, only got one vote because, it just wasn't that compelling.
It was his vote, the narrow ground.
Yeah.
Yeah, he convinced himself. J-Rock who won, not us. And then real quick, because I think just want to get some of these out here for you, Ryan. Actually, this Jefferson Post brought up a good question here. Can the state guards the governor's offered be used? Theoretically, no, because they're not part of the military components, number one. Number two, any of these state guard units are going to be, and if you're in any of these state guards, I'm sorry, but you're not fucking military trained. You're not going to be able to do anything that happens. You have no military bearing. You're not under the UCMJ at any point in time. You're really not under state. Those guys can hand out blankets and coffee during a disaster and maybe help direct traffic. But the Texas State Guard is not on the same level as the Texas National Guard. It's a very different organization. There are some states, I don't know if you're aware of this, Ryan. Some states have state guards, which are solely under the governor's authority, and they're not at all equipped or trained or manned like the National Guard is. So no, those things would be very dangerous. Those people would be, I would not want them doing it because they're not well trained. like that would be a great way to get people hurt or killed using those organizations. So,
well, and then imagine that shit
Yeah.
show. Like,
yeah,
Texas invades Illinois, and
Yeah.
now Texas state guardsmen discharge their weapon and maybe accidentally shoot somebody. Like, I mean,
Yeah.
now we have a Texas invasion of another state. Like,
yeah.
it's
Well, that alone's an issue too. And then let's say that happens, will Texas take him back? And guess what? Greg Abbott's not going to surrender him for extradition.
yeah. So this is it's kind of a nightmare.
And they're
not. It's a different nightmare, but a nightmare.
Yeah, non-federal people on federal property. Like, and if you try to federalize and deputize them, that doesn't work. Like, that would be a disaster in the making. It's a good question. It's a very good question.
Yeah. Your chat is surprisingly in favor of Texas annexing other states.
Yes, well, Alaskan M says, remember for 6 months, thank you, says, YouTube redacted my original comment. Yeah, YouTube does that at times. And Robin Hood asked another good question. How does this apply to Marine security forces on American property overseas? That's different because that's federal property, number one. And number two, it's outside the United States. And it's an embassy. So the president has the authority to protect United States embassies, and it's federal property solely and exclusively. So they are authorized to do that. They're not really there for, even then, law enforcement operations and those situations are done with local law enforcement's cooperation. So if there's ever an issue of a riot or protesting, the local authorities are expected to be involved and take care of that, because the amount of Marines that actually guard an embassy are really, really small. There's not that many of them overall. They wouldn't be able to really do an effective riot suppression detail anyway. So, like, if you're at the embassy and you cause a problem, you're getting, like, if you go to, like, the Malaysian embassy, you're going to get like, the Marines will detain you and then turn you over to Malaysian police. So it's I get what you're getting at, Robin, but it's a very different thing. That's considered solely federal territory, and that would be the president basically handling, almost, you could argue, foreign affairs at that point, if it's an embassy. So the Supreme Court would probably be like, hands off anyway.
A good way of looking at it is just to think about, like, is this a state or is this federal territory, right? Because the federal government's interest in using its forces within purely federal territory is much stronger. That's why, for example, this ruling is not the last word on DC deployment of the National Guard.
Yes. And I think that's the one left.
Your chat is killing me, man.
Yes. It's pulling Judge Dredd. I am the law.
Yeah.
And Jefferson says, joining the brief site unlawful obstruction. Nope.
Not that I've seen.
And it's not very clear. Not very clear.
No, I will admit I haven't like deep dived the briefing before the Supreme Court on this issue.
Yes.
Like I'll probably give them a better read when we have a little bit more time to sink our teeth into them.
Yes.
But I do not recall that was invoked as a ground.
And Ron is saying, Obscure Destination has been here for 18 months. Said, guys, fresh out of advanced individual training, meaning like your MOS training, for out to go do this. It's like you wouldn't want that either, because those guys are not experienced. I mean, they've been trained, but they're not really seasoned, or no. I would rather properly see, like, if you had to do this, you'd send out troops with experience, training, and real world experience. So even those guys, I think it would be a bad idea. Let's see here. Shredder S07 for Ted Sobs. And Jefferson says, in Massachusetts, our state police cosplay as military. Well, yes, there are militarized police, and the Massachusetts State Police all dress like they're invading Poland. So, but that's a thing in the Northeast. All the police look like that. The Rhode Island State Police look like that. I think even in New York, the New York State Police, they wear like the belts that go across and all that too, I think, don't they? I don't know.
We gotta get the fancy uniforms. That's the key.
Yeah, well, the snazzy uniforms and the boots, the high boots. Then EDW Rat for $5 says, suspender snap, please. Also 6'7". Okay, well, there. I forgot I didn't even realize till I got to my mom's house. I was like, she's like, "Oh, you're dressed up," and I'm like, "What? Oh."
I
I was
mean,
like,
you're snappy looking.
"Yeah, that's yeah." Well, snappy with my jokes. Yes, dance for me, monkey. Yes, that's what I do. I'm like Dark Side Phil.
I mean, it's all about the
Yeah,
entertainment.
yeah, it's all about that. It's all about the donos. So yes, Justice Alito and Justice Thomas join. So Uncle Clarence and Machine Gun Sammy come together,
Yeah, they are
and
not happy.
they are doing, as we've joked before and mocked these judges when they're coping and they're coping really hard. They start off with, "You didn't even do it right," and this is an example. In our adversarial system of adjudication, we follow the principle of party presentation. So they say if somebody passes up what seems to be a promising argument, we don't assume the role of advocate. This is just coping right now. Instead, we normally decide the question the parties chose to present. Just you guys, you can make fun of it. You could say this is wrong too, but just replace this with Justice Jackson and Justice Sotomayor, and this is how we're going to go from here on out at this point.
Well, I mean, spoiler alert. Sorry, alert. Spoiler alert. What he's mad about, what they're mad about, is this whole question about regular forces.
Yeah.
Was not briefed at the appellate level. It was at the district court level. Then they kind of arguably waived it at the appellate court level. And their point is, well, why are we even talking about this? They waived the argument.
Yes.
Now, this is really one of these funny things where the Supreme Court's just writing to their colleagues because the court asked the parties to brief that issue. So clearly, the horse is well out of the barn, right? Like the other justices said, we want briefing on this. So how funny would it be if the justices said, we want briefing on this, and then they say, oh, you waived it. Like obviously you were going to lose on this point, but they're just, they're just
I mean, and I'm honestly surprised at this point we haven't seen like dissents to orders like this. I mean, I feel like that's like the next step we're at with this court, because they are getting so, regardless of what side you're on, the tensions are running high that like, I don't consent to this. I think this is improper. I mean, I wonder how far away we are from that.
I mean, we've seen some wild ones. Like I know when you and I looked at CASA, and Kagan had to like point out like to her, her colleagues on the left, like, hey, just because we disagree with the order doesn't mean that we shouldn't reprimand the lower court for not following the order.
Yes.
There's been some weird stuff happening.
But more important, like I'm just saying though, is an order saying we're ordering more briefing, and they could say, we're chastising you for stepping outside of your authority, and it's like, I wonder how far we are from that, because I feel like we're getting there.
Yeah, and look, I'm going to be honest with you, Chad. Like most courts have rules about like if you waive an argument, we don't consider it. Blah. There's all these rules. The Supreme Court, those are all pretty much optional.
When you're the top court
wants to hear an argument, they hear the argument. There's no, that's it.
Yeah, because who are you gonna appeal to? Like that's the best part when you're in charge like that. You can make a ruling and that's it. Because what are they gonna do about it? Nothing.
Yeah, I mean, they're not. What's the saying? They're not final because they're perfect. They're perfect because they're final.
Yeah. Yes, we can never be wrong. Yes, there's a lot of infallibility, even though they don't like to admit it.
Yeah.
Yes, and they say that it raises an argument that was way below, and now it rules in favor on that ground. He says, to make matters worse, the court reaches out and expresses tentative views on other highly important issues on which there is no relevant judicial precedent, and on which we receive scant briefing and no oral argument.
Which is Kavanaugh's point. Like,
yes,
why do this now?
But also, guys, this little part right here, clip that out and put that in the other 24 things we've heard the Supreme Court rule on stay-wise. And it's you could see that at other places too.
What's interesting is that these Gorsuch dissents as well.
Yes.
So they had 3 votes and they couldn't get 2 more. And Kavanaugh was looking, obviously, for a narrow way to proceed. So I almost wonder if there was I would love to be a fly on that wall. Like, what was the politics there? Because I feel like they should have been able to make some kind of compromise, but then Thomas is not a notorious compromiser.
No,
so
he's not.
Yeah. So that
I want to know I want to know when they sat down in their room, because they had to sit down and talk about this.
Yeah.
I want to know how. Oh my gosh! The tension would have been stifling in that room. It would have been suffocating.
Oh my God! Yeah, because
and then the three of these. Well, Gorsuch probably not as much malding and upset, but Alito and Thomas would have been fucking livid at this point.
I think they were probably pretty mad. Gorsuch, by the way, this is just like a total non sequitur. Yeah. I think people, who follow me know that, like, Justice Barrett has often been, she's a Scalia clerk and I'm a Scalia stan. Like, there's I've loved a lot of her opinions. Justice Gorsuch, though, is now vying for my heart. At oral argument, he's been on fire recently. Like, he has been just dropping hammers, asking really sharp questions.
The Slaughter case. Ooh, man, he was taking an axe to that. He took an axe to Humphrey's executor.
Oh, yeah. I mean, it's really interesting watching him, because you get when sometimes you think like all judges think the same. Oh, they're originalists. They think the same. And they don't necessarily. And Justice Gorsuch is on a mission to put every branch of the federal government back in their constitutional box. Like he's just, he wants everybody to go back, and you're Article 1, you're Article 2, we're Article 3, and that's how it's going to be. So I'm here for it. Let's put it that way. Yes.
And they point out here, and we're going to get to we're getting into almost the underlined and caps arguments here. First, the court suggests the principal provision in the case contains a restriction that has no grounding in the statutory text. I don't agree with that. There's no grounding in the text, but I think it causes an issue. And he says, namely, with the regular forces unable to execute the laws of the United States, actually means unable with the regular forces to execute the laws of the United States for, and this is him trying to say, he almost needs to put in little clap emojis in between each word, for reasons other than the lack of lawful authority to do so. The court, in effect, adds new language.
So this is actually an interesting argument he's making. So if you remember, it says you're unable to execute the laws, right? Well, his point is, let's assume that regular forces, this is back to the National Guard statute. Regular forces means active military, as we've learned.
Yes.
The president is unable with the active military to execute the laws of the United States. Well, why is he unable with the active military to execute the laws of the United States? Because it is illegal for him to do so. So and that's not like an unusual thing. Like, there's oftentimes you're unable to do something because the law says you can't do it, right? So his question is, what if we're going to read regular forces your way, fine, but why are we reading to execute the laws of the United States such that it must be for reasons other than illegality that you're unable to use the armed forces in this way?
And that's basically what Alito's claiming here. You guys have literally added on an extra thing, and you're not allowed to do that. You cannot. This is not the job of the court to do this. And they're saying this has entirely been added here.
Yeah. And I think this answers the question that we raised earlier, which is, if they decided regular forces, why did they get into this secondary issue? And this is why. Because there were members of the court who were saying, oh, yeah, okay, sure, regular forces, whatever, it doesn't matter. Because however you interpret that, they're legally unable to use the regular forces, so 3 still applies.
Which, once again, I still don't understand the point then. He says, second, the court suggests that 12-406
you might want to switch back.
Oh shit! Sorry. Yes, thank you. You caught me. Oh, it's great having somebody around and not just me talking.
I was talking into a muted mic for like 15 minutes.
I saw that the one day at one point. I was like, oh no.
I try to avoid it, but
Yeah.
I can't help myself.
See, I got better. Well, what I will tell you is the trick is to monitor your headphones, your microphone into your headphones.
Mhm.
Because when I do it, I use my mixer, and if I turn the sound off, I shut the mic off, I don't hear myself talk. And don't use the StreamYard mute. Use the mute on like whatever you have, because then you can hear yourself and you know, oh God, I don't hear myself, and I stop and I immediately get back to it.
Yeah, good to have a safeguard.
Yeah, that's how I do it. And also you get used to this after a while. But anyways, he says the court implicitly suggests that this does not constitute an act of Congress within the meaning of the phrase of the Posse Comitatus Act. He says that is a surprising conclusion, to say the least. And I don't think that. I think he's making his own argument here, but I don't think that. I think that's a bit of a disingenuous reading of it, because that's not. I think you can clearly say they're not, like, that's not the act of Congress they're talking about that explicitly exempts him.
Yeah, it's weird. Like prior to the court's ruling, there was an argument that 12406 sub 3 was an exception to posse comitatus, such that posse comitatus wasn't violated. That's gone now, but I think that's kind of like the necessary. I don't think that's what they were implicitly suggesting. I think it's the necessary consequence
by operation of
their
law. Yes, yes, I agree. No, I think it's better, and I understand what they're trying to argue here, but I think it's better just state it's literally eliminated, because it's no longer, like, I think he's reading a little. I don't think he's trying to say it's not, like, I think he's wrong in this. He should just say they're saying it, effectively they're saying this no longer exists. And I think that's the proper way he should be looking at it. But I think that's a far more scathing point, is that they've now abrogated, or is it abrogated? I forget how you pronounce it. They've abrogated a statute based on the ruling. Yeah, I think that's a far more scathing indictment of it. And he says, third, the court expresses the tentative view the phrase execute the laws does not include protective functions. And the court didn't get into this, but I could see them going back and saying the president, under his authorities under 3 U.S.C. 301, has the authority to protect federal property.
Yeah, and he says it's that weird bit that they got into where they said, inherent authority is not executing laws.
Yes. And he says, ultimately, according to the court's apparent reasoning, the National Guard members may enforce the immigration laws by, for example, arresting and processing aliens. Which, yes, we could send them out, because that's technically, is that really law enforcement? And he says, but they may not perform the protective functions for which they're better suited. Well, I think that they would say that, no, that counts as law enforcement. Enforcing immigration laws, law enforcement. I think that's the argument. I don't think that's something too tricky for them. They would just say that's law enforcement. So while he thinks that's a, wiggle your way out of that one, they'd be like, okay, cool. No,
I'm not even really sure how he got to that reasoning, because I think a better question would be like, under the court's ruling, what is the National Guard allowed to do?
I agree.
Not much, but I like under the court's reasoning, how would they be enforcing immigration laws?
Well, yeah, and also I would argue that's law enforcement, because you're enforcing the law, literally by definition. So while Alito makes what he thinks is this really intricate maze that you have to get through, this the six are just going to go, oh, okay, cool, and they'll go, and they'll keep moving along. Like you're not really stopping them; they can just sidestep it. Yeah. And honestly, that's a valid sidestep. Like get your way out of that one, and they just go cool, and they just walk away. I think that's correct. I think that's correct. This is not really. This is a swing and a miss here.
This is so far. This is less. I'm less moved by this than Kavanaugh's, to be candid. But we'll see. We'll see how they keep going.
And he says this too is surprising. Well, okay. He said, on top of its court fails to explain why the president's inherent constitutional authority. Also, Ryan, are you okay on time? I know, there's no court tomorrow or anything, but are you okay? I don't want to.
I'm okay on time if you are.
Dude, I can go.
Are we going to do the whole thing? Because this descent is not that short.
Yeah, no, we can plow through as far as we can.
All right, let's do it. Buddy.
I'm good. I'm good. We're strapping in, chat.
Yeah,
we're locked in.
Let's get that content.
Yes. On top of all this, the court fails to explain why the president's inherent authority to protect federal property is not sufficient to justify the use of guard members in the relevant area for that purpose. I agree that's an issue, regardless. He says, I'm not prepared at this point to express a definitive view on these questions. Okay, this is once again, this is that bullshitting. I'm not going to tell you what I really think. It's like, but I have serious doubts. Just, he's saying, no, I think this is all bullshit. And he says about the correctness of the court views. I strongly disagree with the manner in which the court has disposed of this. I don't think there's anything you could convince Alito at this point. He is firmly in this camp. He's not going to leave.
I think he's made up his mind, but also, I mean, I'd have to look at the lower court decision more carefully because I have not read that in a long time, and probably should have before this stream if I had time. But
yes,
I think the argument was, yeah, buddy. Thank you, Raptor. All night. That's how long it's going to take us to read this shit.
Yes.
Thank you, buddy. I appreciate it.
Yeah.
I don't think the appellate court said definitively inherent authority is a no-go. I think they said you relied on sub 3. Sub 3 is a no-go.
Yes.
Right?
We looked at it briefly when it came out, and they just said regular forces are the military.
Yeah. I didn't read the majority's opinion up top as I read that as an interpretation of 12406 sub 3. I don't think they gave any color as to what the scope of the president's inherent authority necessarily is, though when they get into the execution of the laws part, maybe that's what the concern is, that their gloss goes that far. I don't know. What do you think?
I mean, I think it's clear that it's going as far as they can push it. And, 5 of them are willing to go as far as they can go with this. Kavanaugh says he's not along for the ride, but I think if they went that way, he would just say, guys, I don't really like this, but I guess I'm here. I guess I'm sitting in the car with everybody. No, I think it's clear that's how far they want to go with it.
Okay, I'm looking. Sorry, Chad, I'm looking on my screen to make sure I understand what this argument says.
Yeah.
In Kavanaugh says that they rely on inherent constitutional authority that allows them to do that, but the government also claims that performing such protective functions does not constitute executive function in the Posse Comitatus Act. If that's correct, it's hard to see how performing those functions constitute executing the laws under 12406.3. But see, this is the thing I didn't quite understand. Like, Posse Comitatus says that you may not use the military to enforce the laws. Presidents have said protecting the buildings is not enforcing the laws. Therefore, Posse Comitatus doesn't apply at all. It would be, I think, what they're saying. Not therefore we are more limited. I think they're saying that so that they're less limited.
Yeah, but here's the thing: if Trump calls up, like I said, the 82nd Airborne, and they show up tomorrow to the Portland ICE facility, they are not. We're not going. It's not going to turn all of a sudden into 9-0. Like, good job.
I see. So just maybe I'm being slow because So maybe, but hopefully this is helpful for chat. The argument then is the president still has the inherent authority. This is Kavanaugh's point in his footnote, to defend the building. But the specific National Guard statute trumps the general authority, and that doesn't apply. So he has to use different forces. Something like that.
And I think that's ultimately what he's going to say is you still have to use your regular, you still have to carry it out with the regular forces first. Because I think they're going to argue carrying out the laws of the United States includes that enabling statute, like the president's charged with caring for the property of whatever. That's somewhere in the United States Code. It's his duty to care for federal properties and protect federal properties. So I don't think there's any situation where the National Guard could be used until you use the military. And if he did call the military out, these guys would shit a brick over that. Like, you would probably get another 6-3 opinion. As much as Kavanaugh is saying, like, he's okay with that, I think if push comes to shove, he's not going to side. It's not going to turn into 5-4.
Yeah, no. I mean, he seems committed to that, especially on the regular forces. He seems convinced.
Yeah, but I think ultimately, if Trump called, like I said, we wake up tomorrow and there's footage of the 82nd Airborne, they're able to magically airdrop into the ICE facility. Like, they can all jump out of an airplane. They all come screaming in on parachutes. The 6 of them are not going to say, well, you got us. I think that they would have a massive problem with that. And they would say this is still posse comitatus. I think they would still try to say this is law enforcement. You're enforcing the law. I think they're going to say they're enforcing the law. I think no matter what they're going to say, it's enforcing the law at the end of the day. Because you're enforcing whatever statute allows the president that created the Federal Protective Service and enables him to be in charge of that, something in the DHS. I don't think there's any way he can do this. And they're, like I said, I think basically they've written out Section 3. Whether or not they intend this, I think we are now to the point of this no longer exists. This no longer exists, and they're telling him you'd better declare. You're going to have to declare a rebellion, and I guarantee you they will say that doesn't suffice to meet a rebellion.
Well, I mean, because now we're getting into is Trump willing to say there's an insurrection within the meaning of the Insurrection Act,
Yeah,
a rebellion within the meaning of the various statutes about rebellions that we've looked at.
And I think that they would tie insurrection and rebellion together, and they won't let them. Then they're going to say this is not a rebellion or an insurrection.
No, to your point, though, I do think Trump. Okay, I don't know if it would help him very much because, the enforcing the law part is actually kind of important because, like a lot of what he had ICE doing in LA, for example, was going out with the National Guard going out with ICE to stop people from interfering with ICE. Yeah. And that you couldn't do with the military, even under the inherent authority argument. Yeah. It doesn't advance the ball very far. And as we've said, the optics are awful. So politically, it's a terrible idea. But on a purely legal question, if you had them if you had the military parachute in.
Even if they drove it, I'm just saying, theatrically, that would be the biggest thing.
But they didn't do any law enforcement. They just stood there with guns guarding the building. Yeah. And then if when challenged, you said, "Hey, Kavanaugh footnote 2," right? Like, I mean, this is I could see that going. I could see that going the other way, like 5-4. Like
you think you would pull Barrett back over?
Yeah, I think so. Because
Roberts is not gonna. Roberts is gonna be all waffly. Roberts wants to be liked at the cocktail parties.
That's true. It's not going to be it's not going to be a 5-4. It's going to be a 6-3.
To quote an attorney, to quote an attorney I know, Roberts' biggest concern is being liked at the parties he goes to in, McLean or in Silver Springs. I think ultimately they're going to say whatever it is, it's law enforcement. And you're going to see the arguments of suppressing rioters and shooing away people going away. That should be the police's job. But then you run into things like Portland where the police have intentionally stood down. Now, we saw, I think, because the cities were getting scared, you saw Chicago and the Illinois State Police ramp up their response. You saw in Portland, the Portland police ramp up their response because I think they were worried that, oh shit, we basically are saying that it's lawlessness out there. Like I said, I think that they're going to say you have to declare rebellion, and they're going to say that's not precluded from our review. This is not a rebellion.
Yeah. I mean, my take on Barrett, from what I know of her, is that, and of course, like I'm not a mind reader, right? So I'm just reading the tea leaves like any other schmo. But I think she's one of those judges where, like she's like regular forces means this, and as a result, that's what I'm ruling. So I don't think that she's I don't think that she's doing this out of a political motivation. I think that she interprets the law and she holds herself to that standard rigorously. And like her mentor Scalia talked about this all the time, where it's like sometimes the law just does something you don't like and you roll with it. So I think I wouldn't bet in that scenario that it would be that Trump would lose unless, to your point, there were facts that showed law enforcement. But that's the game, right? How do you know what facts there are? And
I guess I'd like to say it like this, though, and this is something where, like, you do this stuff, you've done this stuff, you've been there, done that. I think you're smarter at this than I am. I'd like to think that even Ketanji Brown Jackson at times is a lot smarter and more astute at this than I am. But the idea, they all haven't sat around and said, well, gee, I guess this is what we're implying he has to do. And then, oh, shit, do I really want that to happen? And then, oh, shit, if he really does that, how do I square the circle that I've now made?
Yeah.
You know, and I think that, like, if they haven't done that, shame on them. Shame on them.
Well, and this is, again, the more we read this, the more sensitive I get to, again, not necessarily the legal argument he made, but the sentiment behind Kavanaugh's concurrence, where he's just like, really, as we talk about it more, what's Kavanaugh really saying? Holy shit, we're opening a can of worms here.
Yes.
Couldn't we have said, government, you lose on a narrower ground? Like what? Like these are some weighty concerns that we're opening up here. Again, I didn't find him that convincing, but it would have been. Maybe it would have been nice if he had convinced his. I
think he should. I think he could have been a lot. Well, this is where you need to say, once again, just writing, concurring in part, dissenting in part, doesn't sound like much, but putting that, and dissenting in part, those 4 words, I think telegraph a lot more. I get it. He also doesn't want to muck up just merely an application for an order of stay ruling, but I don't know. Like I said, I'm an idiot when it comes to a lot of this stuff. Like I said, you're here, so I know I'm not doing something stupid. And
no, we're all reading the tea leaves, buddy. We're all.
I know, but I don't. I think there's a lot of we don't know what. Really, this should be. You don't understand what you're doing. None of us do. And I don't understand how you do this. If I'm sitting there in the DOJ and Trump asks me, I'm like, go for it. I mean, we're at YOLO mode right now because it's not clear what they're going to do. Like, if he asked me for what is the legal ruling right now, what is the lay of the land? Like, okay, this guardrail doesn't work. Like, there's not even really a guardrail. There's a white line on the road on this side of the road. What's past the white line, the headlights don't show, but what's like how many lanes and how much road is on the other side? Well, I don't know at this point.
Well, I think what really this comes down to is, do you want to just defend the building? If so, Kavanaugh kind of told you what you need to do, but you're not going to like it. If you want to have a broader deployment that really is actually going out there and safeguarding ICE when they enforce the law, you got to declare an insurrection. You got to declare a rebellion. You got to use some of these powers that are broader. But he hasn't done that because, quite frankly, like the riots in LA, they were smashing cars. They were like, that was those are very different in scope than the protests in Portland, right? Like, I mean,
yes,
if he had said the stuff in LA was an insurrection, I think I don't know if he'd win, but he'd at least have an argument, right? If you call the stuff in Portland an insurrection, you probably aren't.
Portland right now, no. Portland in 2020, where every night you remember seeing that footage, right?
Exactly.
I think, just like the riot streams and people chucking Molotovs into the building and trying to, every night there was a new battle. That would probably be an insurrection, but that's, I think that's the kind of situation you have to have.
I think you're right.
I think that's about where it's going to have to be, or straight up violence. Yeah. Like if a Chaz Chop situation happens, yes. Like, I think Trump could have declared insurrection and suppressed that with the military. I mean, you had a literal enclave of people saying the laws of this nation and everywhere no longer apply. And he could have sent in the 75th Ranger Regiment out of Fort Lewis and whatever military units are there, and actively suppressed it and had people gunning it out with the the SoundCloud rappers that were being in security for that place. That's what I think it would have to be. But without that, I think that we're not at those definitions of rebellion.
No, and I don't think, like, what's happening now, especially as you said, as things have calmed down of late, I don't think really is colorably within the rebellion insurrection category. Not to say that that it hasn't gone there; it certainly has gone there in the past. It's just today, I don't think so.
Yes. All right, so let's keep going here, guys. We're only 9
trucking
pages
through.
Yeah, only 9 pages in 2 hours. It's great timing. We're doing like we're doing like an EFAP here. Every frame. EFAP means every frame of pause. We're not like fapping, like internet fapping. I just want to make sure. I don't know how good your internet lingo is. So
we are filming from the waist up. So
yeah. Well, I don't know what. Yeah, I don't know what's going on out there. I can do a hand check.
Hey, that's not fair. You've got suspenders. Who knows what those things are doing?
Yeah, I don't know where you guys don't know where Clyde's up to.
Oh, Jesus!
You can't. Your door is closed. They can't see what my door is looking like.
Yeah.
All right.
I'm not saying what Sean's up to. I'm just saying that Sean buys $1,000 of Costco peanut butter a month. So
gotta get that fiber in you. All right, so let's keep going though, guys. He says, Ag, we'll cover the Seattle stuff coming up. That is actually very interesting. People are suing the in Seattle when they did this lawlessness. The reason why they did it is because they hated police so much that they speed ran becoming anarcho-communist into becoming heavy-handed police and ended up shooting up a car full of black kids, which was, they did in record time. They became the thing they hated so much, which is very interesting.
I mean,
it's funny when you phrase
impressively
it
quick. That normally takes a generation.
Yeah, it took them a month, and they were already the evil racist cops they were not trying to be. So, anyways, let's keep going. What does Alito say here? And he says this key statutory provision, provides in part whenever the president is able to execute the laws, regular forces execute the laws of the United States, he may call into federal service members in the units of the National Guard of any state in such numbers as he considers necessary to execute those laws. And he says in lower courts, the parties agreed the phrase regular forces means federal civilian law enforcement officers, not military service members. I think the Ninth Circuit said that as well, or agreed with that.
But this is what's so funny. Again, what he's really just chiding the other the other members of the court, right?
You're just making shit up now.
They asked for briefing on this topic.
Yes.
Yes, we get it. Maybe they waived, but your colleagues asked for briefing. I don't know what to say. This issue, you clearly didn't convince them.
Yes, and he says respondents, meaning Illinois, adopted this position in the district court. He says that court disagreed. So even the district court's like, yeah, that doesn't count. But when the government challenged this holding in the Seventh Circuit, the respondents declined to defend the lower court's interpretation, and the Seventh Circuit did not reach the issue. I think they did ultimately. I could have sworn they did. And it says the government's stay application in this court asserted that any defense of the district court's interpretation had been waived, and respondents did not dispute either the assertion or the correctness of the government's contention. Thus, arguing regular forces means the military was either waived or forfeited 3 times over. Well, once again, as you said, they're not final because they're perfect. They're perfect because they're final.
Yeah. And so, I mean, just to decode this, all Alito's saying here is funnily, he's not saying the 6 are wrong.
Yes.
About how they interpreted the phrase regular forces. He's saying we could have avoided deciding this question if we had just said they waived it and we don't have to. Right? He hasn't said they're wrong yet, though. He just thinks, okay, well, maybe we could have avoided it.
Yes, we could have figured something out here. And we didn't. We did not figure anything out. So it's like, great job. Great job. He says, ignoring this history, the court ordered the parties to file supplemental briefs of the meaning of regular forces. He says respondents understandably rode with an argument suggested by the court and argued for the first time that regular forces means the military. And they cite a case, though, that does show that the regular forces means the military. So there's already a Supreme Court case that touches on that.
I haven't read that case.
I'm assuming that's what they're getting at here, because otherwise, why would you cite it? Because otherwise, it would be an improper citation. The majority now accepts this 11th hour argument. Never mind, the respondents presented a contrary theory of the case in district court. And that's usually what screws you, is like you have contrary presentations. And they say for the respondents' own arguments, differently directed fell by the wayside, for they did not mesh with the court's own theory of the case. And he says, we should decide this application based on the party presenting controversy. Meaning, what did you bring to us? This is that's centered on the district court's holding that, contrary to the president's determination, civilian law enforcement were in fact able to execute the laws in the Chicago area. And that's true. That's what the district court said. If the court has doubts about the party's interpretation of the regular forces phrases, it could assume, for the sake of argument, the party's interpretation was correct and proceeded. The court has done that on many occasions.
So if you go back up to that case that we were talking about, wow, this might be lawyer snark. I think you're right. I don't know if the phrase regular forces appears in that case, but when I just got like a quick Wikipedia, like what's the holding of this case? The holding apparently is a federal appeals court abuses its discretion when it goes beyond the questions and issues presented by a party.
Oh, so I was wrong. He's calling them out for being assholes.
Yeah, that's very much just slapping at his colleagues.
Yeah. Oh, wow. Okay. Yeah, because he cites that up here at the beginning. Yeah, United States versus Sinig Smith. Oh, yeah. Ooh, okay.
So he's getting feisty.
And it's not like he's citing something from 1970. It's a 2020 case. So he's calling out everybody but Ketanji Brown Jackson. Because by 2020, everybody else was on the court.
Yeah.
Except Barrett. Barrett probably wouldn't have just authored this. So everybody but Amy Coney Barrett and Ketanji Brown Jackson, he's saying, you motherfuckers know. You motherfuckers know what we're talking about.
Yeah, you know that So he's trying to tell them, you guys really should have let this.
And it's also this case here, though. All of you sons of bitches decided this case, Clark v. Sweeney, in 2025. So you were all here. So you all know. He's like, you sons of bitches. He's like, this is not new. You know better. Wow. And he cites like just belting out cases,
there's
just goes and goes and goes, talking about the Voting Rights Act.
And what's he saying? He's just saying like the court could have avoided deciding this question if it wanted to. Which
there's no good reason.
Correct.
Yes. He says there is no basis for rejecting the president's determination that he was unable to execute the immigration laws. This is him calling out Kavanaugh. Using civilian law enforcement resources at his command. This right here, there's no basis for rejecting it.
Yeah, Kavanaugh, like I said, I think I understand his motivation, but he just feels like a reach.
And Alito saying, quit being a pussy.
Yeah, like, just join or join us, but like this concurrence on the fence thing, that does read like a shot at Kavanaugh.
Yeah. And Brett's like, he's hiding behind Roberts. Like, don't let them yell at me. It's like, can I sit with you guys?
Yeah, I'm kind of imagining now there's like 3 tables in the SCOTUS cafeteria.
Yeah. And that and Kavanaugh's by himself, and he's like, I don't want to sit here.
We wear pink. You can't sit with us.
And hold on one second. I forgot to sorry, for some reason I hate this with YouTube when you update the freaking thing, it doesn't always save, so it never saved the description I had up for hours already. Thanks, YouTube. And he says, yes, and as a court wants to do when they want to, be pedantic, they will review the record. So I will begin. It's like Vladimir Putin. It all begins in 1341. And he says the district court held the president's unable to execute the meaning if he's unable of executing with the regular forces. And it says, this is the appendix to the application. He says, that interpretation is implausible. If the term regular forces means federal civilian law enforcement officers, that interpretation would mean that the president would have to conclude the immigration laws cannot be enforced in Illinois, even if all the other federal law enforcement activities were put on hold on every federal law enforcement officer in the country, including every FBI, DEA, Secret Service, and ATF agent, every postal inspector, which those guys are really good at what they do, and deputy marshal, which the courts would not like that because the marshal's in charge of protecting courts. And all the law enforcement officers employed by other agencies were transferred to that area and assigned to that task.
But I mean, holy pedantic, Batman. Like,
yeah,
yes, you can take a lot of shots at the district court's ruling, and I'm inclined to agree with him. I didn't think the district court was on the money here, but it also doesn't matter like at all to the issue before the court. He's just kind of expressing how frustrated he is with how the courts have been ruling on.
But when you're losing, guys, we've seen this with the other judges. When it's time to cope, the dissent's a great time to cope.
Yep.
Because you just let it all out. Let it all out. You're not going to change anything. And it says the interpretation would lead to even more outlandish results if regular forces means the military. In that case, the president couldn't call up the National Guard to execute the laws in one locale unless all the nation's military forces, and that's the thing, all the nation's military forces, the might of the entire United States military, all the combatant commands, including SOCOM, like Special Forces, Special Operations Command, like the Navy SEALs, Delta Force, the Green Berets, Force Reconnaissance. Nobody could fix it. We got to go to the National Guard. If transfer to the area question would be incapable.
This is all resting on an interpretation of the word unable that a few district courts have tried. He's right. It doesn't make any sense. Unable can't mean 100% precluded. It can't mean that.
We gotta send a carrier strike group into Lake Michigan to come help.
But again,
sorry, can't work.
The word unable was not interpreted by the majority opinion. So,
yes, but I mean, well, since they're interpreting stuff, I'm going to interpret things. I think
he told his clerks, "Have fun."
They're like, "Hey, boss, how big a dickhead do you want us to be?" Yes. Like, okay. So a less extreme interpretation of able is much more reasonable, consistent with the way a term is commonly used. Well, yeah, I'm surprised that you're like, well, what did unable mean in 1792? In everyday speech, a person may say that they're unable to perform an act simply because the adverse consequences would be unacceptable. For example, an attorney might tell a trial court that he or she is unable to start a trial in a day because they're scheduled to argue a case in this court on that date, and no other attorney could prepare for the argument in time. It's a very good argument. It's a very good example. That attorney would be capable of showing up for the trial on the day in question, but the attorney's use of the term unable would be entirely natural.
And he's 100% right about this. It's besides the point, but he's 100% right.
Yes. And he's like, I guess I'll use an example you guys understand. The district court's interpretation of an unable was implausible for an additional reason. It seems to prohibit deployment of the guard unless the president could execute the laws to even the slightest extent, which, yes, how much is unable? Can I only go arrest one person? Like if I arrest, and that's where it's kind of like for like oil and gas leases. The way it's typically done is an oil and gas lease is written like if I drill a well on your land, this lease is active so long as it's produced in paying quantities, which means if it squeezes out a drop of oil and I could pay you a cent, I can write you a check every year for your royalty of 1 penny. That's an payable amount. I can keep that lease going.
Yeah.
And I think, well, how much is unable? How many people do I have to arrest?
That's an insane, this is the insane interpretation of the law. That some lawyers made this argument where they said, well, if the president is still deporting anybody in Illinois, then clearly he's not unable to enforce the law.
Yes.
And Alito is, again, right that that's a crazy way to interpret the word unable. It's just too broad. At the same time, I still haven't seen him land the plane as to why that matters to the issue before the court. So, have fun.
But this is the problem when you're losing. You just point out, look, their argument's such shit. You know what? They probably agree with all this other bullshit that's out there. I mean, it's what we do when we're losing arguments, guys. Just as human beings, we're like, they won. Well, fuck them. That's wrong. That means they probably agree with all the most retarded shit out there. That's just this is a highly educated man coping like a son of a bitch right now.
Anyway, I'm kind of in my head. I'm like, land the plane, Alito. Land the plane.
Sir, this is the Wendy's. Come on. But I understand. But he's malding right now, and you can laugh at him. He's malding, but he is. The district court took what it turned a binary approach: ability or not, capability or not. Well, he says, as the Ninth Circuit explained, this cannot plausibly be read as so long as some amount of execution remains possible, the statute cannot be invoked, regardless of how much execution remains thwarted or how much personal danger is faced.
Are you kidding me? Sorry. He ends the section without landing the plane.
Yeah.
He doesn't connect it
No, we're going to keep going here. Yeah. No,
he's just like, okay, section 1, here's just something I'm mad about.
Yeah. And notice he cites the Newsom v. He cites the Ninth Circuit citing the Newsom v. Trump thing, where the Ninth Circuit's like, yeah, we really can't say that's not correct. But remember, Newsom v. Trump basically got overruled on Bonk by the Oregon thing.
Yeah, I mean, Newsom v. Trump had a better interpretation of the word unable. I just can't get over the fact that he wrote a whole subsection of his dissent without actually addressing anything that was said in the majority opinion.
This is a debate bro situation.
Yeah.
It's justice destiny right now.
Yeah, he's just saying
But to be fair, this is generally speaking how it's going when people are losing a debate one side or another. We're just, this is him also. This is Alito screaming, "Why are you licking sniz right now?" To quote somebody from the right having a bad day. But to be fair, when you're losing, and you're going to grab at whatever's out there. I personally like listening to Andrew Wilson, but I'm just saying, it's an example of, but wait, you didn't address it. He says more. Oh, sorry.
You do see some non sequiturs in Supreme Court opinions sometimes.
But, this is a big non sequitur. Okay, great, but what about what's on the prompt, Sammy? He says it's more reasonable to interpret. Okay, but what about the fucking regular forces? It's unable to execute the laws when he's substantially impaired from doing so. And remember, guys, we're not talking about fucking unable when we're at this. We're not at the unable part. We're at this part. What is regular forces? Now, I agree. He wants to come back and say, no. He's trying to grab the majority and bring them back to, no, you have to address this point. But 6 of them have said, no, we're not doing that. And yeah, when you get to make your own rules, they've decided basically have a mutiny and they're addressing a separate issue. So, oh God, I didn't mean to remove all that. But yeah, anyways. Yeah, he's just like, look, no. He's like saying, no, come over here and address it. And this, everybody else is like, nope, we're going to go this way. Ignore you. And he's like, wait. It's like, too bad, man. We're done.
Don't you want to talk about unable?
Nah. Don't you want to talk about the main issue? Nah, dude, we're good.
This is a Wendy's. We're good. Yeah.
Well, no, but they decided, we're not going to Wendy's anymore. We're going to go to Burger King. So we're taking the car. You could stay here if you want. And yeah, they basically said we're moving on without you. So it's really what's happening. Said the district court erred in refusing to afford any deference to the president's determination by calling up the garbage need to execute the federal law.
Sorry, can I pause you? I know we're going so slowly.
Yeah,
I was trying to remember which of the dissents I've read have like this level of non sequituring where they're just like really upset. Brumfield v. Kane. Justice Thomas wrote the primary dissent. It was a death penalty case. And it was about the victim was the football player Warwick Dunn's mother.
Yeah.
And in one of his subsections, he wrote this lengthy autobiography of Warwick Dunn and like how great Warwick Dunn was, and include photographs from Warwick Dunn's memoir. And all the other dissenters were like,
wait, there's pictures in a fucking Supreme Court.
Oh yeah, there's a picture of Warwick Dunn's mother in the Supreme Court opinion. And all the other dissenters were like, we agree with Justice Thomas's dissent, except for the section where he just gave an autobiography of Warwick Dunn, because that doesn't seem legally operative. But besides that, we're on board. So this isn't quite as good as that, but it's I
mean, we're getting there. But once again, you guys want to make fun of Ketanji Brown Jackson. This is he's got to get laughed at too when he's doing the same things. Even if he's right on topics. Grassroots Hegemon for $10 says Wendy's better than Burger King. It depends on what we're talking about. I would rather eat a fucking Payless shoes than a Burger King. Jesus.
Tell us how you really feel, Grassroots.
Fuck, really? I mean, yes, Wendy's is good overall, but I don't know about as a professional fat guy, I don't think you could tell me what to do here.
So I'm not going to give up my personal data, but I am going to say that there is a slider joint that Anthony Bourdain loved within driving distance of where I reside. So if I want to get good old sack of hamburgers, holy shit, do I have options? It's legendary.
Yeah. Also, KJ real quick says use the black highlighter. Okay, we'll just like the Epstein documents.
Oh man! Speaking of non sequiturs, remember when you and I did a stream and we were like, if they had the right lawyers who were given the right directives and the right resources, Trump could use the redactions to great political effect. And we'll see if they do that.
Yes. It has been all day. It's been great. It's like I said, the whole Trump. Well, and then this Epstein letter thing. This letter that was mailed out 3 days after he died. And I don't know if you've seen that, where it says yes, Larry Nassar, as a fellow mass pedophile, my friend Donald Trump liked to grab young women by their snatch. It's this reads like fucking fan fiction, and it's literally mailed out 3 days after Epstein died. And I'm like, it's
this whole thing is going to
22 months.
It seems like it's going to be a bit clumsy.
Well, every time something comes out and it's wait, you guys are fucking with it. Like I said, it's like that one where they blacked out the name of the girl, and it's wait, that one said Trump did nothing to her. It's okay.
Imagine a world where they actually just released this shit when they said they were going to, and we hadn't spent a whole year talking about it.
Yeah, or imagine Biden and them would have done it, and then they just would have whiffed. Because think about it too. If there wasn't anything there, guess what most people would do then? A lot of people probably wouldn't have voted for Trump. I want the Epstein files.
Yeah.
D-nut the Epstein, you could have done so much to fucking take the wind out of his sails. Okay, fine, here they are. Whoa, there's nothing here.
This is all emails by crackpots who are just
And just think about Trump. Everybody, a lot of people vote for Trump. All right, well, cool. I'm all set. Hey, that's hey. But they think when the orange, he has gotten so many people. It's Captain Ahab syndrome. Anyways, Shredder Ass 07 says this is the kind of thinking that makes me think SCOTUS would rule 6-3 that Die Hard isn't a Christmas movie. They would be wrong. Remember Nakatomi. Yes, that's correct. Die Hard is a Christmas movie. And is Die Hard 2, in my opinion. And then one more. Where's the one other thing I want to get to? Oh, 10K has been a member for 24 months. Thank you.
Oof.
Says Merry Christmas to Sean 2.0 in the chat. Well, thank you. Merry Christmas to all you guys out there getting ready for the holiday. JDK was saying, I wanted to bring this up earlier, when Trump says in the 82nd Airborne, like they need to be playing Fortunate Son on the loudspeakers on the helicopters. That would be funny. And then real quick, another for $20. And I apologize, guys. We're trying to, don't want to break it up, but we got to get to it real quick. It's been a while. So my apologies. For $20 is Merry Christmas, Sean, guest, and chat. Well, yes, Merry Christmas. Thank you.
Merry Christmas to all.
Didn't want you guys to think we're ignoring you, and I'm sorry. It's just when you're riffing, it's hard. You don't want to break it up.
Plus, we've got these riveting non sequiturs to read. So,
yes.
You know.
Zero Fuck says, RoboCop 2 is a turd. Yes, it is an absolute dog turd of a movie. I have a thing about RoboCop 2, so.
Isn't it terrible when they make a sequel, or even like sometimes directors just give commentary that makes you realize that they made a great movie by accident?
Yes.
Or that the sequel team doesn't understand what made the first movie good in the first place.
Yes.
Yeah. Sometimes you get these. You don't want it to color the whole franchise, but it's tough to come back from.
Yes, it is. It is. And Cacophonies is now just trolling. RoboCop 2 is not better than RoboCop 3. That's the thing. I think RoboCop. Have you've seen the RoboCop movies?
Not recently, man. It's been a long time. But I have seen them. Yeah.
But you know, like how there's the one where he fights the samurai robots and he's got the jetpack and everything. Okay, RoboCop's the one series where like everybody's seen like the first part of it and the last part of it, but most people never got to watch 2 because 2 is so shitty. They never show 2 on TV. They don't really show 2 anywhere. And 2 is like an even worse storyline. There's like a 12-year-old gangster in the middle of it that's like running around as like a bad guy. And it's the most obnoxious storyline ever. But it's an awful movie. And most people think they've seen RoboCop 2, but in reality they've seen RoboCop 3. So that's been my thing. We could do it more at another point, but
I feel like we should reach out to like Sarah the Raging Tomato and get you and Cacophons on there. Yeah. RoboCop 2 or RoboCop 3, we duke it out.
Yes.
Full debate night just on this.
Yeah. Okay. All right.
The follow-up can be you and Grassroots about hamburgers.
Yes. Oh, yes. Has anybody seen the remake? The remake sucked. I did not like that.
I didn't even bother. It didn't look.
Oh, it was awful. It was awful. So, anyways, let's keep going here. And he says the most directly relevant Supreme Court precedent suggests that such a determination must be accepted by the courts, and that's Martin v. Mott, where the guy got called up. And he says that in that one, the militia member, among other things, that the standard calling up the militia under the law enforced at the time had not been met.
But I mean, holy shit, Alito! Like they're not ruling on this.
Yeah,
like,
they already decided. Yeah, we moved on.
This is Kavanaugh's issue, but like they didn't rule on this, man. Okay.
Well, technically they kind of did. They're saying the standard is what are the regular forces that you need to execute the laws of the United States. So in a way, kind of, but
the quality of the president's declaration. If the president's saying I declare that ICE can't enforce the laws of the states, and you're saying regular forces can't be ICE, the statute's totally changed. The president's declaration doesn't matter anymore.
Yeah, I think that's a fair way. No, you know what? That's I'm trying to think ahead here on some of these things, but yeah, that's correct.
I think
because it goes back to the idea of we've now basically eviscerated what this provision means.
Honestly, I think that he's Alito here is kind of like what was that Clint Eastwood movie, like Gran Turismo? Like he's yelling at kids on his lawn.
Yes, Gran Torino. Yes,
yeah, Gran Torino.
Yes, get off my lawn. I'm like, I have my Garand behind me too, so I could and now I could do that when the kids in the neighborhood come around and they start fucking around on my property. I can point that at them. It's perfect.
That's the dream.
It is. This is Section 1 of that law govern the use of militia when the country is invaded or threatened with invasion. Okay. And Section 2, much like 12406, authorized the use of militia when the execution of federal laws obstructed. Addressing the Section 1 standard, Justice Story's opinion for the unanimous court held that The authority to decide whether the exigency has arisen belongs exclusively to the president.
Okay.
Yeah, I mean, that's great, but the court's not going to do that. The court is not just going to defer.
Honestly, you did this whole legal analysis earlier where you drew a line with a sidestep.
Yeah.
And then another line. That's it. Like, this is a very interesting argument about a point the majority didn't make.
Yeah, they're going, whoop, okay, cool, we're going to keep moving.
Yeah.
Yep, they're just like, sorry, cool, neat. They sidestepped it. Where it's like a guy in the NFL, just, I'm spinning around, sorry. But I'm right here. I don't want to get tackled.
Yeah, this is exactly what they were arguing in the lower courts. Mm-hmm. At the district court level, the appellate court level, this is like Mott, that was exactly what they were arguing. But in Martin, but now, with the new ruling, it doesn't even matter, really.
Yeah, but there have been other times, though, where these determinations, like the Alien Enemies Act, the Supreme Court said, like, you can't just do whatever the fuck you want.
Yeah.
We're they tried to say that. The Supreme Court's like, no. You get to do a lot of things, but we get to decide if you could still do them.
Well, but this is a great example, right? Because, let's say normally we're always talking about this. Like, does the president have the authority to make the declaration, and how much deference is he owed? Right? That's always the topic. But if the Supreme Court said, you know what, we've looked at the Alien Enemies Act, and we think the word alien enemies actually means only uniformed military combatants. Well, now the president's declaration doesn't matter, because if he says, like, Trinidad and Aragua are alien enemies, it's like, well, not anymore.
Yeah.
Like, we said they're uniformed military combatants. Your declaration, even if your declaration is perfect, it says the wrong thing. Right?
Well, I agree. But I'm just getting to that idea of, but just every time this comes up, every argument, they always say, well, yeah, you have no authority to review this. And the Supreme Court has every time said, like, yeah, no, we do have authority to review this. Yeah. You don't just get to make a decree and that's it.
A little bit. They reserve the right to kind of say, like, yeah, we're gonna, if it was, there's not no review, but it's hyper deferential review.
Yes. But that's the thing. They're like, we're not just like, you don't just get to do it. Like, we do have some say. And even with the Alien Enemies Act one, they're like, yeah, no, we're still here. Yeah. And that, I think that's something, even in this one, they're going to say, no, we're still here. So this authority to decide whether it has arisen belongs to the president. No, that's not, the Supreme Court would not support. You would not get enough votes to support this, I think.
Well, you'd obviously get Alito's vote, because the next.
I get Alito and Thomas, but maybe Gorsuch, but you're not getting 5 votes.
Well, I'm curious if Gorsuch. That's actually interesting. I wonder if Gorsuch joined this dissent or just wrote his own.
Yeah, well,
because this doesn't sound like Gorsuch. This sounds more like Alito and Thomas.
Yeah. And they say his decision the court held is conclusive, and therefore application of the statute depends only on his own judgment of facts. Yeah, the Supreme Court, like, they're not. U9O and JGG said you can't just do that.
Yeah.
Which is, once again, this is a man who's mauling right now, because there was no dissent in part on JGG. You're just like, yeah, you can't fucking do this.
Yeah, this is not. I don't know who he's trying to persuade here, but it's not.
Yeah,
I don't know. It's not. Yeah, other than Thomas, I don't know who he's aiming this at.
Yeah, and once again, he's talking about the unreviewability of the president's decision to call up a militia. It's like, you have not supported this in any other context. It doesn't work. Also,
he's still dunking on the district court decision. Yeah, it just has no bearing.
Yeah, it's done. Yes, and he goes back. He's going back to the person he can kick the shit out of at this point.
I should really try that the next time I do a debate. Like, if it's going badly, like, instead of engaging with the topic, just start doing crowd work. Like, fuck you, Chatter, you fucking bastard.
Yeah, just pick on a Chatter. It's like, listen, this fucking Garrett guy, just fuck him. He's so fucking wrong.
God damn it, Garrett.
Yeah.
Sean and I were about to, like, totally unravel this Supreme Court case for you guys, and here you are, just one-guying us.
Yes.
Fucking Garrett.
Yes.
Jesus.
Yes, the district court gave no weight to this precedent. Okay, we're not dealing with that. It saw Martin as a relic. viewed its express holding as limited to particular facts of the case, and thought it had been superseded by more recent political question decisions. I would argue it has been superseded by more recent political question decisions.
And again,
yeah,
unrelated to the majority view, but yeah.
But I mean, do you agree? Like, I think mod has been like we've had a lot of institutional implementation of civilian control, but more importantly, statutory control of the military.
Yeah.
Since then,
I actually thought the Ninth Circuit, the original Trump case, was pretty good on that. Where they said I agreed with them. Like they said, like, we don't think it's like completely a rubber stamp, but we think it's a highly deferential review. Like, we're really not here to replace your judgment with ours. We're just here to say, like, if you say it's a rebellion and it turns out there's nobody there, we have a little bit of a problem on our hands, but we're not here to, like, draw fine lines.
You can't call a drum circle a rebellion, but like, people, trying to burn down the building, that's probably making it hard for you to do your job. And like, when they locked all the FBI agents inside the warehouse, like, okay, that sounds like things are getting out of hand. Like, okay, you're probably right on that one. But this idea that you could just like do whatever the fuck you want, I'm like, no, I don't even like that idea. I don't like the precedent that would set.
Yeah, there's got to be some reviewability. It's just deferential.
Yes, because it's like, I'm sure that Alito when the Biden administration is coming in there, it's like, oh no, I actually don't have any authority here to review this. Yes, Marbury v. Madison is important, but on this legal topic, no. You can actually do whatever you want. I can't say. Like, are you really sure about that, Sammy?
Yeah, I think what it kind of looks like is the like in the context of impeachment, the court will never ask if the thing you impeach someone for was serious enough, right? Like, but they are going to police the boundaries. Like, did you count the votes right? Yeah. Did you actually say it was a high crime or misdemeanor? Did you have the declaration? Like, they're going to check that the procedure is followed. They're going to check that you're not like outside the perimeter of sanity, but they're also not going to say, okay, you impeach this guy for jaywalking. We don't think that's serious enough, because they're not going to make the judge. They're not going to replace the judgment of the Senate.
I think if that was the case, so I think they would. Because they'd say, generally, we're not going to get in the way of it, but you don't get to be completely retarded about it. Like, they're going to say, you can be pretty retarded about it. You could come up with some goofy shit. But, like, we can't just say, oh, because he, jaywalked, you're going to impeach him. Like, we're not going to let that happen. I think they would have like, because this is, so? I mean, I think because it's kind of like the whole, deference to Trump, deploying the guard. Like, okay, we're not going to say it's impossible, because they're saying there are limits. And I think they would say, like, yes, you cannot invoke it because there's a drum circle. The facts clearly do not state that you're unable to carry out the laws. Or, one time that the people got in the way, you missed the guy you were trying to catch. But like every other time, like, it happened one time. I think there are some limits. I think the court would say, like, we can't get in the way. Like, we normally won't get your way, but you don't just get to act completely unhinged.
You got to be really careful with that stuff, though. I don't know how they've worded it. Maybe they'd have to come up with some clever language, because the issue is, could you imagine a scenario where the Senate impeached somebody?
Well, right? Remember, I mean, Marbury says what the law is. Well, what's this Constitution? What is a high crime and misdemeanor? I think that would give them the authority to say, what is the law?
Yeah, but what I'm saying is, imagine like.
Oh yeah, that would be insane.
If they were convicted and the Supreme Court said no, and it wasn't for some clear legal reason, it was like, no, we just don't think it's serious enough.
Yeah,
like, holy shit. I mean, I think you like they'd be like, well, guess which court has 35 justices tomorrow? I
agree. That's the thing. But
you're in crazy constitutional crisis land at that point. So you got to be careful.
Yeah. Well, I think so too. But I think also, though, if we're getting to the point of somebody's getting impeached because they jaywalked, it's like you could have probably found something better at that point to impeach that guy on.
I take your point.
I don't know. It seems I don't know. Whatever.
Yeah, it's interesting because they've used like the Trump immunity decision. They've used this language about conclusive and preclusive. Like there's been a lot of jurisprudence about there's certain things that a branch gets to do and the other branches don't get to say anything about it. Now, is impeachment one of those things? I don't. We don't have the case, but I guess we'd find out if somebody ever got impeached for eating a ham sandwich.
Yeah. That's. Hey, we had prime rib tonight, so my mom was like, "Oh, we're good." She's like, "Oh, well, we're fixing that tonight." I was like, "I'm not going to complain."
Prime rib? No.
It was very nicely done.
No complaints there. That's a nice dinner.
It was very nice. Yes, hella steamed hams. And he says such treatment of Supreme Court precedent that has never been overruled. Well, it was never ruled upon. Like we haven't had to deal with this since 1802. Narrowed, we haven't had to deal with it. Or a question by this court was inappropriate. It's like,
okay, let's assume he's right. The district court was really, really wrong. The district court was super wrong.
Yes.
Got it. Changes nothing. Like I don't know what to say. But.
Yeah.
Oh my God, he's going to another section, and he's
yeah.
Okay, dude, he's killing me right now. This is brutal. Sorry, none of this connects to anything.
No, it doesn't. It doesn't. We're still going, chat. And he says, even if Martin does not dictate judicial acceptance of a decision to call up the guard, I don't think it does, Sammy. Both that precedent and a humble appreciation, because you guys are all I've said it before, people like being lawyers because at the end of the day, deep down, we're all prima donnas. But you are a Supreme Court justice. You are the epitome of a prima donna. Like the idea that you're not some like legal monk. You are a prima donna through and through. It's humble. Yes, I'm sure that's something every Supreme Court justice has been. Of the role of a single federal judge, surely demanded such a presidential determination be given a modicum of deference. The district court afforded none. Okay, we're way past that now, buddy.
I can't.
He says, for these reasons, the district court appears to misunderstood what the law requires, and those errors alone justify. Okay, great. Also, that was already we pivoted to another topic. The prompt changed in the middle. Yes.
Alito does not like what the district court did. We understand.
Yes.
Okay.
Thank you. Once the proper legal framework is recognized, okay, Jesus Christ, where are we going with this? The president's determination must also certainly be sustained. No. Once again, it's not carte blanche.
Let's land the plane here, buddy.
Yes.
Let's land the plane.
The government's declarations, once again, at the trial court level, guys, we're back to the trial court again, show that ICE operations in and around Chicago have been the target of unprecedented sabotage and violence since June. Hundreds of rioters have converged at the DHS facility, the only intake and processing of ICE operations in Chicago. These rioters have been organized, gathering off-site and arriving in vans, getting picked up several hours later by fans returning new rioters. Yep. Not disagreeing. But they've arrived.
Again, I just keep saying this because I feel like I'm like a crazy person right now. If regular forces means active duty military, none of this matters.
Yeah.
Like you have to read regular forces to include ICE for this to have any relevance to the legal issue.
And right now, the majority has not said so.
Yeah. So it's very strange. I guess. Okay. No need to belabor the point. He's clearly, we get what he's doing, but he's just he's just laying it all out there.
Yes. And he puts out the resulting, blah, 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 blah. The resulting violence has endangered the lives of federal personnel. Multiple rioters have been found with loaded guns, some of them semi-automatic. Most guns are semi-automatic. Jesus Christ. And notice this is the guy known as Machine Gun Sammy when he was on the Fifth Circuit. I don't know if you know that's what his nickname was back in the day. There was like when he got nominated and stuff, like because he had made a machine gun friendly opinion about like the Fifth Circuit. Like some guy showed up and had a machine gun case. And he's like, yeah, I'm actually okay with machine guns. Everybody's like, based. It's like, yeah,
It's a good nickname.
I don't consent. I don't shit on Katanji this much. She's a fucking retard. I expect a little more out of this guy. I'm toughest on the people I support.
It's not that he said anything like look. His logical, like you could agree with it or disagree with it. He has all kinds of logic here. My frustration with the opinion is that he just hasn't written anything that matters yet. Yes. Like he's been clearing his throat for a long time.
Yeah, he's writing like this is a majority opinion. Yeah. And it's like, yeah, you lost. And, if let's say you went down the road, you'll have all the time to gloat and tell everybody how retarded they are some other point. Right now, it doesn't. This is just whining.
Like if you read the great dissents, like I think like Morrison or Scalia wrote a lot of great dissents.
Yes.
Obergefell, the dissent is masterful. The great dissent tells you why the Constitution required something different.
Yes.
And it kind of fills you with purpose up front. You're not left reading like a long recitation wondering where it's going.
Yes. Oh, my dot's still on. Good. Sorry, I was just making sure I got to keep that thing on me. Yep, the light's still working good. Gotta check it every once in a while. The writers have done all these bad things. Horns and whistles. Oh, no. That can cause hearing loss. Well, wear some ear pro. On more than a dozen occasions, the rider jumped on the hood. Okay. And when the vehicle stopped, other riders ran up and slashed tires. Okay. On a widely publicized event on October 4th, a federal vehicle carrying Border Patrol agents was boxed in on a public road by 10 civilian vehicles. These guys, they are lucky, especially the Border Patrol dudes. Mm-hmm. Like, that is like a ambush tactic. And like, depending on if those guys are dudes operating down on the border, like, I'm just saying, have you seen Sicario, Brian?
Yeah.
Yeah, you know that part at the border where those guys, everybody gets down at the border checkpoint?
Mm-hmm.
That is like they're lucky nobody just started just pounding it, just right away, because that is when you box everybody in like that is...
No, I mean, something very bad could happen, right? Like, that's a military tactic. Like, you can't...
Yeah.
It actually kind of reminds me of some of the arguments I had.
Like, if I was a group of people and we boxed in a police car somewhere, I'd expect that cop just start throwing copper at everybody.
Oh, yeah. Well, it's kind of like when I was arguing with people about Rittenhouse back in the day.
Yeah.
Some people would say things like really crazy stuff. They're like, oh, well, they were just reaching for him. I'm like, they're reaching for the gun he's holding.
Yeah.
Like when somebody's attacking you and you're holding a gun, you can't let them grab the gun. Like, if you let them grab the gun, then they might kill you. Like, there's certain things that just trigger lethal force.
Well,
this is a lethal force scenario.
Mm-hmm. Yeah, and I've seen and I've been to classes before where the guy's told me, he's like, if I could grab your gun, it's my gun now. It's not even if you're holding onto it, if I can grab onto it, and yes, YouTube, there's nothing on screen, but if you could grab onto it, and it's now just as much your gun as their gun. And especially if it's a rifle like Kyle Rittenhouse had, especially if it's on a sling and somebody grabs a hold of your gun, you're basically tied to something they could swing you around on.
Mm-hmm.
They grab your gun. This is just, And anyways, he goes on and it's serious business.
A lot of bad stuff. A lot of very bad stuff.
Mm-hmm. More, we get it, Alito. It's getting really bad. Yep. He says, even when not on duty, federal officers have been targeted. They have been followed to their homes and doxxed. As far as getting doxxed, I don't actually have a problem with that. The doxing, the screaming out where they're at, that's, hey, man, you have a shiny gun and a badge. That's, you took this, if you didn't think bad guys would get mad at you, go fucking sell cookies or something.
So a lot of very, frustrating, bad, and difficult stuff was happening to ICE when they were attempting to enforce the law in Illinois.
Yeah, apparently, I still think this is bullshit. The bounties for kidnapping and murdering them. More than 20 have had their home address posted on social media, and posts have called for officials to be shot and killed on site. Yeah, well, did it happen? Like, I mean, like, the moment that happens, Trump goes insurrection, boom. And you know the court's going to go, yeah, actually, yeah, we're probably at that stage. So,
yeah, I mean, there was that ICE shooting a while back, right? Like, if that was happening in Illinois, like if they had, then you have a good argument.
Yeah. No, I mean, that's the thing. Like, the moment that happens, the Supreme Court's you'll probably get 7-2.
Yeah.
Yeah, it's no longer our problem now.
Can we scroll and see where he's going with this? Because I'm not sure.
So you didn't read all that. Okay, yeah. The Chicago Police Department had an internal dispatch that said no units will respond to this. Okay, and some threats injury. He's still going. The district court again. Holy fucking shit, man.
He's really
my God.
He's really playing his fucking organ here, isn't he?
And he's like, second point about the district. Hold on.
Okay. I would just go to part 2. I would just go to part 2.
Okay.
He's playing the fucking organ. Okay. All of part 1, I don't think means anything.
That was 9 pages of nonsense. Instead of abiding by the standard rule, the court took it upon itself to raise a question of whether the understanding of regular forces was correct.
Here we go.
Yes. And he says that taking a cue from this court, the respondents abandoned their position and switched the argument that the phrase refers to the military, not civilian enforcement. He says, the court tentatively agrees with the new argument, but even if that is correct, it does not follow the president exceed his lawful authority when he called the Guard into service to assist in executing federal laws in Illinois. No, that's not.
Okay. So so now he's going to make the argument that even if regular forces means what what the majority says it means, then, and hopefully, chat, he's going to redeem himself here, because the first part frustrated the crap out of me. But now, hopefully, he's going to. This is, I think, where he starts making the real argument.
So the provision asks whether the president is unable with the regular forces to execute the laws of the United States. Okay. And the president said unequivocally that he had determined the regular forces of the United States are not sufficient to ensure the laws of the United States are faithfully executed in Chicago. He says that, but once again, he's relying on the idea of we can't question his determination.
See, this is actually...
And he can't do that. I would not, if Alito said that, I would say that is incorrect.
Well, here's the thing about what he's saying here. He's basically saying the president made this determination. We're not allowed to question the determination,
which is not at all acceptable.
But which is kind of wild, because he's also saying we understand the majority changed the meaning of the statute, right? So whatever the president thought he was saying would now be incorrect, because the statute is now read differently. But yet we still can't look under the hood of his declaration.
Yeah, that still doesn't work for me. Not at all. This is still more coping. You can't do that. There cannot be any. This idea, because like I said, the JGG opinion's enough. Oh, I can do whatever I want. And they're like, no, you can't. Well, you've already, there's no other time would he do that.
I mean, the reason why I tend to agree with you, Sean, is just at least on a policy level, is like, you always got to imagine the other side gets this power in the future, right? Yeah. And then it's like President AOC, mobilizes federal forces to fight climate change, and then says she's unable to do so, and then mobilizes the National Guard across every red state. And obviously it's bullshit, but we're not allowed to review the declaration.
Yeah. I agree. He would say no. No, and that's what I was saying earlier. This idea you could do it.
What's going on, buddy?
Yeah. Well, you say they don't even pretend to deal with that issue. Well, yeah, no, Alito's not addressing that issue here. I agree. Yeah,
I think
we've already said this is a man coping out of his fucking mind.
Yeah, I think Pisco, we've been unimpressed with this dissent so far.
No, nothing here has been. Not only is this statement sufficient on its face, it's not. But under the presumption of regularity, the court must presume the president properly arrived at his determination. Once again, Martin is not we have Martin is not. This didn't exist when Martin v. Mott was decided, or Mott v. Martin was decided.
But again,
this didn't exist. This didn't exist. Like, none of this existed.
I think that there's a lot of areas where the president's owed a lot of deference.
Yeah.
But the idea that you would say we owe so much deference that we have clarified the meaning of the law so that the term regular forces has changed. So the president declared point A in time. There has been, regular forces are unable to enforce the law. Point B, the meaning of regular forces is clarified such that what the president thought it meant, it no longer means that. Point C, Alito says, even though the meaning has changed, the declaration is unreviewable. That's really stretching credulity.
It does. And I still think the biggest thing, if he wanted to make an argument, it's still the argument I think that makes the most sense here. By doing this, the way that the majority's done it, this is once again, this doesn't exist anymore. And we just now have two options. It's either a rebellion or an invasion. I think he just state that and leave it.
I think that would have been much more convincing. At least it would have been clear. Like, again, Kavanaugh's concurrence didn't convince me, but I at least understood where he was going. This seems like he's arguing for a rule where he'd say he's arguing for a rule here where the presidential determination is unreviewable. Yes. Not in a situation where it's hypothetically wrong or even when it's probably wrong, but in a situation where we know with certainty it is wrong because the law has changed after he made it such that it is not possible for him to have been right. Right. That's a very different claim. You're talking about like when there's a 0% chance that he's right, it's unreviewable. That's not like a 90-10. That's a very different thing.
No, and like I said, this would have been a far better argument for him to say, you basically have just made this completely worthless.
Yeah,
I think that would have been a far better, because then what's the majority going to say in response to that? They're like, well, technically no, but if I can't suppress things with the army, guess what? We're probably in a rebellion or we're under invasion. Those are the only two options. Because if it's so bad, I can't have the army fix the problem. Like, and they mean the entire, like, the military. Okay, well, if I can't have the 1st Marine Division fix the problem, things are probably really bad, and the National Guard's not going to fix it.
Yeah, I mean, certainly prong 3, where prong 3 would apply now, I don't think it's. Like, if you think of all the use cases in the world, I don't think it went from like a full set to a null set, but I think it went to like a 0.002% set, right? You know what I'm saying? Like, I think there are probably some hypotheticals where 3 gets invoked without the Correction Act being invoked. I just think they're going to be vanishingly few and far between.
And I can't like it. I mean, yeah, sure, there might be some times, but what are those times going to be, and how often are you going to have them?
Yeah. All right. Well, let's see if he lands this plane, because what I've been wanting to see is his argument that he previewed, which is that if you're unable to do something legally, then that counts as unable. So the fact that the president is unable to use regular forces would allow him to then use that. That's the argument I've been looking forward to. I don't know why he's been throat clearing for.
No, we're building up to, I get hopefully something here, but he just we get it. The district court was dumb, is his argument.
Yeah.
Here he goes. Looks like he's getting to it. So the majority does not explain why the president's declaration falls short. Okay. Instead, it breezily concludes that a president's inability to execute the law cannot be established unless the military could legally. God damn, hate when it does that. The military could legally execute the laws. They say, in effect, the court adds the new language, so the statute now requires the president being able to execute the laws of regular forces to execute the laws of the United States for reasons other than the lack of lawful authority to do so.
Yeah, so this is the argument. He's saying He's saying that legal inability should count.
Yes. And he says, we have no authority to add this new language to the text Congress enacted.
Okay.
Yeah. He says the sole requirement set out is he must be unable to regular forces to execute the laws of the United States. That text says nothing about the president's inability to execute the laws. And it does say he's unable to execute the laws. Then in ordinary usage, it is common to say that a person is unable to perform an act when the obstacle is a rule of law. And he says, for example, it would be unnatural to say that a person who is fully capable of operating a motor vehicle is nevertheless unable to drive to work because his or her license has been suspended.
Okay, so the example is if I say I'm unable to drive to work, that doesn't necessarily mean that I'm physically unable. It could mean that I'm prevented from driving to work because I have my license suspended. The law prevents me from driving to work.
But the rule of law being an obstacle, I mean, that's kind of how the law is meant to work. It's meant to be an obstacle.
Okay. Can you switch back to the National Guard statute to see this?
Yeah, sure. Which the
12 okay. So, you crossed it out.
Yeah. Well, that's what I'm saying. Like, basically, it's kind of what they do with that. I mean,
so
I think
I'm just trying to figure out how Alito's argument would work. He's saying the president is unable, with the regular forces, to execute the laws of the United States. That means military.
Yeah,
so
we're going to say military for right now.
So
he's going along with it for the argument.
If Alito was right, this would mean the president is unable, with the military, to execute the laws of the states because other laws prevent him from doing so.
Yes,
would be like a valid interpretation of this.
I think that's what you'd have to go with. Yes, is what he's trying to argue.
The problem I would have with that, and just this is just off the top of my head, is remember, like, posse comitatus makes most use of the military illegal, right?
Yes.
So
unless it's exempted.
So if you took Alito's reasoning, wouldn't that mean like the National Guard could be called up basically all the time? Because like if you're unable with the military to execute the laws of the United States, and you are essentially always unable to execute the laws of the United States with the military because of posse comitatus, then you are unable to execute the laws of the United States, so you can then call up the National Guard. That would seem, that would seem to cut broadly to the point where the National Guard could be called up in all other scenarios. To your point, it's weird. Like the majority's reading makes three. Let's not call it total. It's not surplusage, but let's call it like vestigial or near surplusage. But his reading would make 1 and 2 surplusage. Like, why would you ever do this?
Yeah. Well, I mean, they're both kind of maxing one way or another, and you know it.
I'd like to see. Sorry, go ahead.
No, go for it. What are you gonna say?
I'd like to see how he develops the argument. Like I'm curious how he goes with it. But his reading seems to be doing quite a lot of violence to the statute.
Oh yeah, this is. You know, it doesn't help that he spends however long now fucking screaming like a retard for page after page after page.
Yeah, I might have been more sympathetic if he didn't make us read fucking 10 pages of just being mad at the district court.
Yeah, I mean, like, well, it would. I'd have a little more like, okay, what is your argument other than 10 pages of I don't fucking like this? It's like, okay, great. Like, I understand you don't fucking like this. What are we dealing with? It's like when you read like KBJ and she's fucking going about retarded stuff. Okay. What is your point? And he says, or to take one more example, it would be natural to say that a federal district court is unable to adjudicate. Well, okay, so you're saying it would be natural to say a federal district court is unable to adjudicate a case in which the plaintiff sues a citizen in the same state under state law. Well, yeah, arguing diversity jurisdiction. Yeah, but that. I don't like that. I don't think that's that's too easy of an argument. That's too easy of an argument. Like, that doesn't sound right to me.
Well, I don't think he's grappling with the extent to which his ruling, like, there's ramifications of the majority's ruling that you've pointed
Yes.
out that you're frustrated with, but
Yeah.
the ramifications of this ruling of his version would be
Just as bad.
Much broader. I mean, I think
Yeah.
this would increase the president's ability to use the National Guard exponentially. I mean, it would be near plenary.
Yeah, but I'm just saying here, like, I would need to sit here and say, you need to explain this to me like I'm 5. Explain this to how this applies, because I cannot figure it out. This is too easy of a, well, here's a case where it wouldn't work. I'm like, that's too easy for me. Like, there's got to be, you are inferring too much into this that it doesn't work. Like, I don't understand how he's using this. It doesn't.
I think we got like 3 pages left. I think I have the stamina.
Yeah. Oh, hold on. What's Pisco saying? It's like citing the diversity jurisdiction purposes of civil lawsuits for ability. Yeah, it's when I can't even figure out how he's trying to do it. It's, once again, this is a guy he's fucking flailing. He's crashing and burning right now.
Yeah, in the context of a law that's about the ability to enforce the law and about like rebellions, emergencies, to read Section 3 as creating the ability to use the National Guard in essentially any situation where the military is not allowed to enforce the law, which is all of them. That's all scenarios.
Yes.
That would turn a statute that's about using the National Guards in emergencies into a statute about using the National Guard in all scenarios, which, like, I'm not necessarily like a congressional intent guy, but like there's just no possible way.
I agree. But I also think, though, if you were to, do the congressional intent of this, the idea that this may never, on the same token, this is now only applicable to like handfuls of potential issues. It's like, then why didn't they just list out those probable issues? So I think that's I think you run into the issue both ways.
Well, and I think this is kind of Kavanaugh's point where he's saying, like, boy, this regular forces ruling is really changing how we interpret the statute. Like, unavoidably. Like, if you go with the majority, it changes it a lot. If you go with the Alito, it changes it even more.
Yes.
Maybe we should try to find some narrow ground. I wish he found a better narrow ground. But, like, I'm more and more appreciating his sentiment, if not his logic, right? Where he's just saying, oh, this is going to be.
Yeah, I mean, like, I agree. Like, what does this change? Great. Okay, cool. But they've changed. They've made the change. Like, it's, okay. He says, by the same token, if we apply the ordinary meaning of unable to, a president may be unable to use the military, was kind of what you just said, execute the laws due to either practical or legal constraints. Well, yes, the legal constraints at this point are all the fucking legal constraints, which are unless it's expressly authorized. And I mean, I would argue this is clearly not an express authorization, because there's no. This isn't like the one here where you're using the militia to come in, or using not the militia, but the National Guard to enforce a court order.
I mean, could you imagine if somebody said, like, it turns out I am unable to.
You get what I'm getting at here, right?
No,
like, that's an explicit. This is not an explicit thing, so I don't Yeah,
no, and I think to your point, like, could you imagine if somebody said, like, well, we can't use Space Force to enforce immigration law in Colorado, therefore we get to deploy the National Guard.
Yeah.
Oh, that doesn't
like
seem
you
like
weren't allowed to. Yeah, you weren't allowed to do that anyway. Like,
you were never allowed to.
Like what we were talking about earlier, I would argue enforcing immigration laws, by definition, law enforcement.
Oh boy. Okay. Well, at least we're getting to the hopefully the end of the cope.
No, I know, but that's where I think it still would. No matter what, that's still you're enforcing a law. Therefore, by definition, you are law enforcement.
Yeah.
So, yeah. And he says, even if 12406 contained the extra requirement, the court adds, there would be reasonable grounds for concluding the president had the authority to take actions at issue. Okay, well, what are they? I mean, yes, that statement alone, yes, he could have authority. Okay, well, what's your argument he does? Indeed, the court seems to acknowledge as much. It notes the president invokes his inherent constitutional authority to use the military to protect federal property and personnel.
Yeah, this is the Kavanaugh footnote 2 point.
Yeah, okay. And it cites with apparent approval of a body of OLC opinions sanctioning this understanding of inherent presidential power. And yes, it's to deal with the Vietnam era demonstrations in 1971. Yes, we did touch on this.
Okay.
And he says that is what happened here.
Ooh.
Okay.
I mean, I think that is part of what happened here.
Partially, yes, but that is not what happened here.
No, because the president's memo, we looked at it earlier, Chad. Yeah. The president's memo said expressly, and I made this point earlier, that they were there to stop the prevention of the execution of federal law.
Yes.
Now, I think they also had a mission of protecting federal property, but it wasn't just the federal property.
No. And remember, I still think you run into the issue of suppressing a riot, if we're getting to this point now, does constitute law enforcement still, because that is a traditional police power, is putting down disruption. So
yeah,
it then turns into basically they have to stand there inside and they get to hold the doors closed, and that's about it.
Yeah, I don't think. I mean, we talked about this a lot. I don't need to belabor the point. This decision might result in presidents thinking that they should use the military rather than the National Guard to protect a federal building if it came to that. But anyway, that certainly their mission here went well beyond that. But anyway, let's keep going.
He says the president authorized the National Guard to perform those protective activities that the Secretary of War determines are reasonably necessary to ensure the execution of federal law in Illinois and protect the federal property in Illinois. And they cite the memo. Although the court,
so he admits it's both things. It's not just
yes,
one.
Okay, and that's yes. And he says, he talks about protective, and also, the execution of federal law. Well, there you go. That is a lot more than what happened here to. And he says, although the government recognized this as inherent presidential power, it does not explain why it is not sufficient to satisfy the new element the court has added to 12406.
Well, it's not a reasoned opinion. It's not fully reasoned. Yeah. But they did give a little bit.
Yeah, they did. They did explain.
Yeah, they said that the president has consistently taken the position that defending federal buildings is not executing the law because it's an inherent power. And my theory, though, again, chat, please don't hold me to this because I've not done the research on this yet. My theory is that presidents have done that because of the Posse Comitatus Act, where they don't, if it's executing the law, then they have a Posse Comitatus problem. But if it's not executing the law, then they can defend federal property without having a Posse Comitatus problem, which you would need it to be read that way. So I don't think it's crazy that the presidents have taken that position previously because they would want to maintain their power.
Yes. And he says, the government seems, the court seems to suggest the Posse Comitatus Act, once again, we've already been here previously, says that stands in the way of what the president did here, but that is puzzling. It's not really that puzzling to me. He says, does the court mean to suggest the Posse Comitatus Act somehow limited the president's inherent constitutional authority?
I think they did. I think they said the opposite.
Yeah. I don't think they did.
I quite frankly just don't think that. I honestly think they did the opposite of that.
Yeah, I would argue that. Yeah, I don't.
Yeah, I'm not. This argument's not doing it for me.
Well, no, and the problem is when you're trying to figure out something that doesn't make fucking sense, sometimes you just have to say, this doesn't make sense instead of trying to figuring out what he's getting at.
Yeah.
I think if he was sitting here, it would take him like 45 minutes to explain it. And if it takes you that long to explain it, this doesn't make any fucking sense.
It's taken us 2 hours to read it.
Well, yeah, but that's what I mean. Like, if it doesn't make any sense, there's... they say this is somehow that is certainly not Congress's view. I don't think Congress would say they've been able to. Yeah.
I literally don't think anybody thinks this. I think everybody believes that protecting federal property is an exception to posse comitatus.
Yeah, and here I will say, I'm just going to answer this here real quick. BobTube for $2 Australian doodles says real lawyers on stream, fake lawyers in chat. Guys, Pisco is a real attorney. Ryan has interacted with Pisco in real life. He is a real boy. He is a real life human being. He is not AI. He is, in fact, an attorney.
He might look made in a lab. He might owe me $50, but he is a real attorney.
Yes. He is a real attorney. Okay, so and Alito's here saying at 12:4, this may help us here a little bit. At 12:406 is triggered only when the president determines he is unable to execute the law by using the military. It is not easy to see how a court could access and reject such a determination. Well, once again, this is just him saying, "Well, we can't review it," and that's a non-starter for me. As discussed, inability under 12:406 should be interpreted to require no more than serious detrimental consequence. I think that's unable to. Okay, you can't get it done, and therefore the statutory predicate likely be regarded as satisfied whenever the deployment of military units for the purpose of executing the laws at home would have such consequences.
This is his argument that about unable, that he was. Yeah, I didn't like it above. I'm not.
No, he's literally restating it again. Assessing the impact the impact of such a deployment will require a survey and analysis of all the nation's military needs. No, it wouldn't. It would not require that. And only a president under his command are equipped to make such an assessment. Yeah, no, I'm not. Nope.
Yeah,
nope. We're moving on.
I feel like if he had written a different dissent, he might have been able to get more support from the judges. But this is like a classic. I'm not trying to get anybody else on my side style dissent.
Yeah, no, this is him just.
Yeah,
this is a weird. This is him riffing.
This is a very strange dissent.
Yeah, and he says the posse comitatus act is not a complete barrier to use the armed forces for a range of domestic purposes, including law enforcement function. It pretty much is, because, as it fucking says, unless expressly authorized, by the Constitution or an act of Congress. So yes, the insurrection or rebellion, okay, great. Or Congress passing a law tomorrow that allows them to do it. Yes, it is a fucking limit.
I think what we're getting into here is like a little bit of kind of like a circularity type thing where
this is like
I was saying earlier, before regular forces was interpreted by the majority, there was an argument that regular forces meant all federal forces, including ICE. And then you say, well, if regular forces are unable, and if you don't have an insane definition of unable, it includes that they're impeded in a meaningful way, substantially impeded, let's say, then you can call in the National Guard. And that kind of made sense. And then you could say, well, that is an exception to posse comitatus because it's an express delegation from Congress. But now that you've defined regular forces as active military, I just don't think I don't think this argument works. So this is all kind of downstream of the definition, and he's kind of collaterally attacking that because I don't think. I mean, we've been doing this for so long, I've kind of blacked out. Has he even said that he disagrees with that regular forces means active military?
I don't think we've gotten even to that point yet.
I don't think he said that. I think that he's talking. I think he's talking around it, which to me, again, I haven't deep dived the letter briefs that were submitted by the parties. But if we get through this whole thing and he's unwilling to say the majority was wrong about the single most important issue, and he just keeps collaterally attacking them, then I am going my strong inference would be that the evidence is strongly in favor of the majority's interpretation. Because if they were wrong, he would just say you're
Yeah,
wrong.
well,
And
that's
here's
what
the
I mean.
history.
He would have
Yeah.
said you guys are retarded and just cut it short and like you guys violated all our principles to do it.
Yeah, it would be like a 2-page thing. Like your definition is wrong. Here's the evidence.
You should be ashamed of violating all the rules we normally adhere to.
Yeah,
and on top of that, and that could have been like ABC and done.
Yeah, I think my I'm getting a little bit nervous about how much talking around the issue he's doing.
Yeah. So he says when the use of armed forces is authorized by an act of Congress or the president determines the use of armed forces is required to fulfill the president's obligations under the Constitution to respond promptly in time of war, insurrection, or other serious emergency. He says, and in any event, the Posse Comitatus Act expressly permits the use of the military to execute the laws permitted by an act of Congress, correct? And 12406.3 is part of such an act. No.
I mean,
no, that is not. No, I would not.
Yeah,
that's not an express provision. Because if 1203 or sorry, 12406, if this is an express provision, God, I have it on the wrong thing here. If this is an express provision, if he's saying this is an express provision, then why do I need to worry about why would we need this or need that?
Well, and again,
it wouldn't work.
If you kept there was an argument that could be made under the old definition and not including his like legal inability argument, which I think does all this violence to the statute. But again, that ship has sailed because regular forces has now been defined. So I feel like he's at sea right now. Like he keeps circling. Like the key issue is the redefinition of regular forces. And
that's all we need.
He's trying to peck at it from the side, but he's not actually,
no, because
he's not actually making any full-throated argument.
He won't address the issue. And he says the court finds the Posse Comitatus Act relevantly large, stroke mouth here. The court finds, court finds the Posse Comitatus Act relevant largely because the same phrase executes the laws also appears in 12406.3. Well, yes, the Posse Comitatus Act should be fairly relevant when we're considering what we're doing here. The court's reasoning appears to go as follows. Under a position long taken by the government, the PCA does not forbid the use of the military for protective functions. Okay. This must mean the performance of such functions does not constitute the execution of laws. I think everybody would agree with that.
I'm with you.
Yeah, I think that's a correct statement. 12406.3 allows the use of federalized National Guard members to execute the laws. Which law are you trying to execute? Because that's the issue.
Well, I mean, 12406.3 authorizes what it authorizes. If execute the laws does not mean protect federal buildings, then it doesn't authorize that. It authorizes something else.
Yeah. But no, I'm just saying, like, which law? Because, I mean, we talked about Eisenhower. Whatever enabling statute allows me to protect federal property. Okay, cool. But that's not what's been cited. It's to allow ICE to do their job. Okay, well then, yeah, that's going to be falling outside of it. Therefore, it falls the National Guard may not be used for protective functions. And that's not at all what they're saying. That's not what they're saying.
Oh my! So if the court's reasoning rests on, sorry, he's gonna attack the presumption that the exact same words in a related statute should be interpreted to mean the same thing.
Yeah, okay. That's not. Yeah. He says the court's what?
Go ahead. I was just skimming to see whether he actually gets around to regular forces. Spoiler alert: I don't think he does not.
Okay, well, there you go. That tells you where he's really at.
Yeah.
The court's reasoning rests on the presumption that a phrase has the same meaning when it is used in closely related statutory provisions. That's generally correct. That's how we operate. That's generally how fucking things work. Like, you normally do that. Like, once again, when you're not sure, you can do, like, that's generally what you can do, especially in a place like this, because, You're in Title 10. Guess what we have? We have motherfucking, we have definitions.
Yeah, we can look through.
Like, we have definitions and rules of construction. So guess what? We can go to the idea that, yes, if they're all next to each other, they are closely related.
Mm-hmm.
Yeah, that's presumption is not conclusive. In this situation, it would be pretty conclusive, though, because we have definitions. Right.
It's not conclusive, but it's damn good evidence.
I mean, you're going to, make that, please, I'd love to hear Alito try to argue with the statutory construction issue. That'd be another 45 minutes and he wouldn't actually probably get to it. And he says that presumption is not conclusive and there are reasons to question its application here. No, there's not. Like, there's... The LC's interpretation of the posse income tax is based heavily on the history and purpose of that act, not the ordinary meaning of the phrase execute the laws, which easily encompasses protective functions.
So he's arguing that execute the laws should mean something different in the two statutes.
Yeah.
Okay.
Mm-hmm. Okay.
Oh, he's not even really arguing that. Sorry, I was skipping ahead.
Oh.
At the bottom, he says we should not hastily dismiss the possibility that interpreting it this other way would, so he's not even really saying, he's not even going so far as to say, I have an alternative reading that's right. He's saying the majority, which, let's be real, this is an order, it's not a reasoned opinion. The majority, which gave like an unsigned, very, very brief summary of its thoughts, didn't fully convince me of this point, and I think there's wiggle room left. That's kind of all he's saying.
If that's what he's saying, this is a fucking waste of space for a dissent. To get to that point here, because there's ways you could do this.
Honestly, this is
pretty fucking pathetic for Alito.
Pretty bad. I am not an Alito hater. He has written some opinions I like. This is not one of them.
Yeah, this is like one of those nights where, like, as much as I may make fun of KBJ, like the opinion she wrote in the Ames case about the employment discrimination, fucking laser beam awesome. But there's other times where, like, even Kagan's like, bruh, what are you doing? Somebody really, what are you doing here? What are you doing here? He says, moreover, one of the LC's reasons for narrowly interpreting the Posse Comitatus Act's reach was to avoid intrusion on the president's inherent Article 2 powers. Yes, the Nixon administration was very, very narrowly construing statutes that will limit the president's Article 2 powers. No fucking shit. No fucking shit that would happen in 1971. Really? No way. No way. I mean, like... that's not to say Nixon was wrong on things, but, like, that's not... Okay. All right. Anyways, the president's constitution should protect federal functioning inherent authority to use troops necessary to carry out this duty. Okay. Interpreting the phrase execute laws in accordance with the ordinary meaning of its terms would not pose any similar problem. If you really thought that, why isn't he citing the statute like we talked about? What's the enabling statute that allows the president to protect federal property?
There is none. It's inherent.
I think there's got to be power. I think it's an inherent power, but there's got to be one. There's got to be something. It's like 3 USC. It's kind of like what Eisenhower had. 3 USC 301. He's got something.
But this is what I mean. Like we're at the end of the opinion, and he still hasn't just said the one thing that needs to be said, which is I disagree with the definition of regular forces.
Yeah.
So I mean, this is all kind of noise at this point.
Yeah. And real quick, I do have to get this. Well, Mr. Ubercross saying, I'd be curious about your thoughts on this false state of electors. Well, I guess we could address it at the end here. Sorry, I didn't see that was on the different topic. We can address that in a minute. And then real quick, Stephen Cooper with 50 subs.
50
Let's
subs.
fucking go tonight, chat. You get a little getting a woo from the dog there. Thank you, Stephen, for your support, your generosity. Much appreciated. And
I would be delighted to have a fall slate of electors conversation. Probably
Yeah.
not tonight because it's fucking 1:40 in the morning, and I
Yeah.
gotta go to sleep pretty soon.
Me too.
I am now approaching an end to the stream shot at some
No,
point.
I understand. We're like got 3 more pages left.
I feel like I'm committed to this now.
Yeah, no, we got to land the plane if he won't. The pilot's dead. The pilot's in the corner, screaming. So he says, interpreting the phrase execute the laws in accordance with the ordinary meaning of its terms would not pose any similar problem. Well, but yes, this state, this alone, I don't have a problem. Like this sentence specifically, I don't have a problem with, but it's when it's part of this sweater. No, I don't.
Well, but that's what I mean. This is all driving to his conclusion.
Yeah.
Which, is merely that it is therefore entirely possible that the phrase has different meanings in 12406 and the Posse Comitatus Act, which is it's a very, when you're arguing with someone and their conclusion is so weak, it's impossible to disprove.
Yeah.
They're saying it's possible the sun will rise tomorrow. And you're like, yeah. I mean, I guess.
Yeah. Well, it's like me if my guy's fucked. Yeah. You're not 100% sure he's guilty, ladies and gentlemen. Anything could have happened.
Yeah. I mean, beyond a reasonable doubt, who knows what's reasonable? 100%.
Do we know? Yes. Yes. Are we not men? To quote Rob Norris. Yes.
Yeah. Oh,
yes.
boy.
Are we not fallible? Are you sure? We all mess up, guys. Are you really sure you're reasonable? I don't know. Have you ever been unreasonable before and you thought you were being reasonable? It's imagine I've never been that desperate. I made that fucking argument, but I really wanted to before. And I'm like, they're going to look at you and say, I'm a fucking idiot. It's yeah, because you are. That's what he's doing right here.
Yeah, this is the the desperation mode. I'm mercifully, Gorsuch's dissent is very short, which means I think he actually has a short and clear point to make and makes it.
Yes, and he says here, on the contrary, under Article 2, the president must take care that the laws be faithfully executed. Okay,
sure.
And laws protecting federal officers and property are not accepted. Yeah, okay, well, which one is it? Nor do we read the Insurrection Act, which authorizes the use of military and armed forces to enforce the laws, as preventing the president from ordering troops to serve protective functions. And this is 10 U.S.C. 252. And this is the thing we talked about with Eisenhower, where he's like, I can use the court, I can use authority here to go do it.
But also, again, and maybe I'm just missing the thrust of what he's saying. The Insurrection Act has not been invoked, and it's not before the court. And I don't think if the president declared that there was an active insurrection in one of these places, I think this would be a very different case. Certainly, it would not be a subsection 3 case.
No,
it would be a subsection 2 case or a subsection 1 case.
Because I'd argue you could say, but this court would say rebellion, insurrection, same thing.
Yeah,
at that point.
So why does that matter? We're talking about sub 3. We're not talking about sub 1 and 2.
Yeah, which. Yeah, I don't know. I don't even work here. I don't even work here, and I have to figure this out for him. It's entirely possible that the phrase has different meanings. You read ahead here, okay?
Yeah.
Especially since what 12406 authorizes not the regular use of the military, but the National Guard. Well, yeah. Once again, this is okay. It's entirely possible. But it doesn't. We would need 3 hours for him to explain this. I think we should not hastily dismiss the possibility because interpreting 12406 the way the court suggests would have very strange consequences that Congress is unlikely to have done. I'm sure that Congress would not have wanted 12406 to be so narrowed in scope, but that the court's made that decision now.
Yeah. Again, if you don't want it to be narrowed, you have to attack the definition. Yeah, that's what narrowed it, right? So if they're wrong, say they're wrong.
Yeah, just say it. Let's just fucking tell them.
Let's go, man.
National Guard members could arrest and process aliens. No, they could not. That would be fucking law enforcement because you're enforcing fucking laws. They couldn't sit there and check my fucking duck stamps on a marsh. That's enforcing a law.
It's a very weird thing because he's saying, like, yeah, there are scenarios where the National Guard could do that.
This is not that would literally be enforcing
is unable
a law.
To.
Yeah.
It's theoretically possible, but basically not possible.
But no, his argument here, though, under the court's interpretation, they could do all of that, but not have protective functions. No, not at all. I think that, yes, you would get Kagan, well, maybe not Kagan, but Sotomayor and KBJ would shit themselves if Trump sent in troops to hold the doors closed and protect the facility, but they would not say that they could go out and check, do immigration checks or anything like that. Nor would I want them to do that.
I think this is shadow boxing. I think that the limitations that are imposed here would prevent National Guard from doing ICE's work in basically all scenarios. So,
yeah. Oh, I think so too. Our country's traditionally aware of using soldiers as domestic police. Yes.
For good reason.
That's why we have a fucking Posse Comitatus Act. Because we didn't like how the fucking military governors were doing shit in the South. Although some of that too was also people in the South trying to get rid of the military governorship, and there's some, I can understand some of that argument that was a little bit of lawfare there. But I also think people realize we don't want to do this. We really want to get rid of it, and the rebellion's over at that point. Fair enough. I get it. The court's interpretation assumes that Congress has meant that for provision to turn on this approach on its head. Okay, great, but say why it's fucking wrong. Tell me why it's wrong.
In conclusion.
Yes. In conclusion, my straw man, the court should have decided this application based on the arguments the party chose to present. Okay, great. Yes. I agree with you there. You're kind of stuck with, you run what you brung. And on that basis, should have granted a stay. Okay. Interjecting another issue in the matter was unwise. Okay, great. I agree. What about the fucking definition here? Is you're not even arguing why the definition is wrong, man. He just leaves that one out on the field.
See, honestly, this whole thing could have said they waived the argument below, so we didn't have to do this. I think there are very good policy reasons why we shouldn't do this. Therefore, we shouldn't do this.
Yes.
Right?
I mean, this beginning is what he like.
This could have been.
Here you go. This thing right here. This is perfect.
Yeah.
This beginning part's great, and this part is great. Like, we should have just stuck with that.
That would have been a fine dissent. Like, this is a very serious issue.
Well, he could have addressed some other points too, but just come in here and be like, look, we're I'm gonna, my first part here, boom. That's all. Like, start off with that's great. It's clear, it's concise. We understand they're wrong. We get it. And then address to us what regular forces means and why that's wrong. But instead, he just
endless. And the thing is, I think he hurt his own credibility because he advanced. It's not like I don't have my concerns about how the majority interpreted the statute, but his interpretations were worse.
Yeah, I don't fucking want what he's selling either.
Yeah, so that's what I mean. Like, if the answer is all these interpretations are bad, then the correct thing to say is, hey, they waived the argument and we don't have to decide it, so we shouldn't, and we don't.
Yes.
Right? So, I mean, I'm hoping Gorsuch, who I've been standing recently, has a more measured approach to this issue.
Do you have do you have his picture up on your wall? Like, you get a little heart around it. You're like, together forever.
I was thinking about it. I found a YouTube channel that puts up the picture of the Supreme Court justice when they're talking for oral argument. And
you gotta put a filter on.
After Gorsuch just annihilated on Slaughter.
Do they do it for every? Do they do it for every argument?
They've done a lot of them. They started doing more and more.
I need you to send me that channel because I saw you covering it the one night. I was like, I really like that.
Yeah, just having the little visuals really nice.
Well, yeah, it helps a lot. It helps a lot because I normally know who's talking, but sometimes you get confused.
Especially when the judges are when the justices are interrupting each other,
yeah,
or like having like back and forth. Like, yeah, it's nice to have a little guidance.
So what does George Gorsuch say? Well, this case touches on sensitive and gravely consequential questions concerning what roles the National Guard and U.S. military may play in domestic law enforcement. I agree.
Mm-hmm.
To be sure, as the parties observed, Congress has supplied us with some relevant statutory guidance, some scant, on 10 U.S.C. 12406. But as my colleagues' writings attest, the statute raises as many questions as it answers. Correct.
This is mercifully clear.
This is what you point out. We don't know what he's like, we don't know what we're doing here. And I got concerns.
And this is big boy stuff. This isn't like, how do we figure out what the deductions are in like a niche tax issue? This is when are we allowed to defend the country? When are we not allowed to defend the country?
Yes.
And how? This is
the limits of Article 2.
So, like this is maybe an area where we should have more briefing. Like that seemed okay. I'm loving this so far. This makes sense.
Yeah, this is just like Alito. He started out super strong.
Yeah.
Take some examples before calling for the National Guard. Under this, the president must be unable to execute the laws merely with federal civilian law enforcement personnel, or must it be able to do so with military troops? This is the question.
It's the question. That's the question.
Yeah, is a presidential declaration he is unable to do that judicially reviewable? And if so, what extent under the standard? Yeah, this is how you address it. Yeah. Does it provide standalone authority permitting the president to deploy the guard? And how does it interact with other statutes in the field like the Posse Comitatus Act and the Insurrection Act?
I like the humility here because sometimes justices, especially with statutory interpretation, like the Constitution, there's this whole built up philosophy of how you interpret it. But with a statute, you don't know. Like, the statute says this. We really don't know. We're trying to figure it out the best we can. These are really serious questions. These are big questions that the statute on its face simply does not answer. There's no guidance in the law.
Yes. Everybody else is screaming. There's 6 people screaming, "Oh, it's obvious to me." 2 other guys are saying, "No, it's obvious to me." And this guy's like, do we really? I don't really know if we know what's clear to us.
Mm-hmm.
And I think I haven't read all this yet, but I'm assuming he's going to say, since I don't know, I have to dissent because I don't want to fuck with it.
Yeah, I'm assuming so, which is the cautioned and reasonable action. Do you know what you're doing? No. Are you going to change? It's it's the fence argument. Why is the fence there? There's probably a reason for it. Don't just fuck with things. Oh shit! Is Chapingro still in chat? Sean did Chesterton's fence. Chapingro bothers me about Chesterton's fence every stream. This is his pet issue.
Yeah, here we go. He's not worried about the old man yelling at clouds. I'll just aim to channel my inner Alito. Merry Christmas, gents. Well, Merry Christmas.
Merry Christmas, Chapingro.
But I mean, it is. It's the argument of what's also the argument. It's the Malcolm. What is Dr. Malcolm argument? You thought so much about whether you could do it that whether you should do it.
Yep.
I mean, like he's saying, like, should we do this? Like, can you do it? Yeah, you do whatever the hell you want. Should you do whatever the hell you want?
Yeah, like, is the court in a good position to issue law on this point now?
Yeah, and this. I like this here. What, if any, inherent Article 2 powers of the president to deploy the guard to protect federal property, and how might that inform the interpretation of 12406? Another great question.
Another great question.
Ching. Yes, I agree. Yeah. And if, as all parties seem to assume, today's guard is a successor to the militia of the founding era, it is, how can this inherit presidential authority, well, not necessarily the founding era, but as things progress through history, the governors had state militias they could call up to suppress revolts and, unrest. So, yes, like the state militias that were called up throughout, like the Civil War, I would argue, when the states are raising their own military units. I mean, that's about as close as it gets to the National Guard.
It seems like the modern analog. I don't know. I mean, like he says, is it the successor in a legally cognizable way?
Yeah, and there's some militia acts, and yes, technically, me and you were still in the militia, technically.
Yeah, I mean, they're assuming it, but it's a fair question to ask, I guess. But
yeah, and if all parties assume it's a successor to the militia, how far can this inherent presidential authority extend before it intrudes on Congress's prerogative to decide when the militia may be used to execute the laws?
That's another great question.
Yeah, I don't know.
because there's a tension there. The president has a power, Congress has a power.
Mm-hmm.
You know, when there's overlapping powers, there's an issue that you know might need to be resolved.
Yeah, and if this we're not fraud enough, an even graver question. And this is a very grave question.
Mm-hmm.
When can the federal government deploy the military for domestic law enforcement, consistent with the Constitution? And that's also a big fucking question. But can
we talk about how mercifully clear this writing is?
Yeah.
Like Alito's writing is giving me like real conniptions trying to figure out what he's talking about. This is crystal clear.
Yes. In the present posture, I'm not comfortable venturing an answer to any of these questions. Sometimes the best move is not to make a move at all.
Mm-hmm.
You know, sometimes this is the Whopper logic from War Games. I don't wish to play the game anymore.
Yeah.
Yeah.
Never mind. I was about to make the point, but he says it right. He's
saying we've never decided a case about this, let alone explored its interaction with other statutes.
And just to give some context there for chat, like often when the Supreme Court issues an order in a context, there's lots of law. So the order, if it's not like a full reasoned opinion, doesn't have that much weight. But here, the order is going to be the most influential thing ever written in this context. So maybe be careful, because there's, you know, like we're actually writing with indelible ink right now.
Yes, and that's the thing. Like what we say, like, we are shaping this, and the Supreme Court always, they try to narrowly like, okay, well, we're gonna like, let's tweak it, like, okay, we're gonna bring it in a little bit. Instead, they want like this and went already, instead of skipping like what may have been 5, 6, 7, maybe 15 cases to whittle it down. Instead, we're just like, no, we're here.
Yeah,
and now you're gonna have like,
I'm going to use this case as an example because people get mad when I say things like they're like, in the Trump immunity context, for example, they'll say like, oh, well, Ryan, are you saying that Trump can use the military to assassinate a, I don't know, a sitting senator and be immune? And I'm like, I don't think so, but they didn't decide that issue. It wasn't before the court. And it's actually important that the court not decide issues that aren't before it in situations like that, because why are you deciding a hypothetical question? You're doing it off the cuff without proper briefing.
Yeah, that's an advisory opinion at that point.
It's an advisory opinion. And here, if I understand him correctly, he's basically saying like, look, like there's a lot of tough questions here. We had this on emergency briefing on an injunctive relief. Like, can't we just wait for it to come up the normal way?
Yeah, and Kavanaugh's example is a great example. Okay, let's say the military can't get there in time. Does the courthouse just burn to the ground? Sorry, nobody can get to Cleveland, Ohio in time. Sorry, Northern District of Ohio, it's getting burned down. Have a great day. Like, is that what we're saying?
Yeah,
I mean, it's.
Or at least give the parties full briefing on regular forces, right? Like they did letter briefs, right?
Which are just very supplemental. I mean, how many pages is a letter brief normally?
Yeah, I mean, they're normally like 5 or 10.
So a 5 or 10 page brief that is going to have resounding effects on constitutional law for the rest of history.
I mean, these were a little longer. These were like 14-page letter briefs.
Okay, still 14 pages for you to shape constitutional law for fucking ever.
Well, and it's certainly not what you get with like regular briefing is the way it is for a reason. It's a lengthy process with a lot of input, a lot of research. It just, you get more out of it. Oral argument would have been great on this issue. Yeah. I would have listened to the shit out of this oral argument.
I would have too.
Like I'm very sympathetic to what he's laying down.
Oh yeah, I am too. Nor do we have much help on these matters from the parties' briefs before us. Yeah, because this case they don't have anything to work off of. They all work off the same set of sheet music. which at this point is just make it up and we'll decide who's got you guys both bake a cake and we'll decide whose tastes better.
Well, also
what cake do I bake? Yeah, whatever you think.
I mean, the research is so hard here. There's no cases, so all the research is going to be like deep dive legislative history stuff. Like it's totally possible that with more briefing they could find more stuff.
Yeah, he says this comes to us on an interlocutory posture, which once again isn't Barrett always been like, I don't like shit on interlocutory, and these judges have really hated dealing with interlocutory things, and they bitch about it left and right. Oh no, this one's good. We're just gonna interlocutory. We don't know nothing about it. Yeah, well, this is the one we really want to kick our shoes off on.
No, the question that I don't have an answer to it right now, so I'm gonna pose it and not answer it. Why did the court give a reasoned opinion? Why not just say, the stays good, right? Your
stay denied.
Yeah, your application to overturn the stay is denied. Government, fuck off, right? And then it goes back to the lower court, and then they can decide all this later. I'm wondering why they felt the need to do it now.
I have no idea.
That's an interesting question.
Every other time they just say go the fuck back down.
Yeah, they don't normally give a reason.
Yeah, they might, it's been a page.
Last paragraph, Sean. You can do it.
This is something weird. Under these circumstances, caution seems to me key. Yes. I would decide this application narrowly, based only on a few arguments the parties preserved, and the evidentiary record as it stands, and he cites
the same case.
Yes. He says in their initial briefing before this court, the parties proceed on the premise that its statutory permits the president to call up and deploy the guard when he's unable to execute. And he says, proceeding on that premise, I believe the declarations of federal law enforcement officials support a grant of the stay and substantially the reasons given in notice. This is where Gorsuch is saying, I'm not co-signing all this bullshit.
Yeah, he says like,
I'm not 1A, 1B, C, and D. He's like, I am not co-signing all that fucking nonsense.
Yeah, I mean, I think what he's saying is like, look, without cross-referencing it, there was some very bad stuff that happened to ICE. Yeah, and there are at least counter arguments to some of, like, is it certain? No, but there's counter arguments, and the parties waived. So, given waiver, the possibility of counter arguments and some bad facts, let's be cautious.
Yeah. And honestly, if you really want that stuff to get briefed, say, hey, you guys have waived those arguments here, but go make the arguments back down, bring them back up. I would hazard no opinion beyond that. This is wisdom. Leaving instead all the weighty questions outlined above for another case where they're properly preserved and can be received the full airing they so clearly deserved. This is wisdom, chat. This is wisdom.
This is a wonderful dissent.
This isn't even really cope. It's just like, I don't think it's cope to say I'm not in a position where I think I can properly adjudicate this question.
Yeah, look, here's the thing. I could see somebody, like, I get the arguments the majority is making, and I get his position, right? Like, these are well-reasoned positions. And also, God, he could do it in like 2 pages. So, I mean, yeah, like, if you hate this decision, and I think a lot of people will, I would encourage you to say Gorsuch was right. I would not run around saying Alito was right if I were you. That's going to be a tough. That's going to be a tough plane.
Notice Gorsuch. This is Gorsuch's way of saying this idea that, once again, the president is immune from review. He's not co-signing that. He's like, there's some of what you said was right, but yeah, this is, because like, let's say Alito and Thomas were gonna, like, let's say that's all they talked about, Gorsuch's like, I ain't buying that. I ain't buying that. But yes, this is a man who's like, look, we don't know what we're doing here. We don't know what we're doing. We shouldn't start messing around with this. And yeah, this is what you guys should, this is what we should be supporting. This right here is just a crazy man screaming.
Yeah,
This is a man who lost. He's pissed off and upset. Cool. This is a guy who's like, took a deep breath, sat back and said, look, here's the problems. Here's what I don't like about this. It's hard to argue. Like, you can't, there's nothing to find fault here.
If somebody said to me, like, Gorsuch was right, or if they said to me the majority opinion was right, I think that's an interesting argument I would have with them, because I see the wisdom of both, right? These are well-reasoned positions. I'm gonna have to sit with this for a while to decide. I like Gorsuch's caution. This feels like it was too fast on some level, and maybe that's why the majority was using the word likely so much. They were saying, oh, the statute likely means this, and it likely means this, instead of, being full-throated. And if all the Supreme Court's going to say is likelihood when they're interpreting the law, maybe they should say nothing. And I think that's a fine point to make. I think Gorsuch, I'm very impressed with this. I've been very impressed with him recently, and he did not let me down here at all.
No, and this is once again where I don't know what Trump and the DOJ guys are thinking. And I'll say this much. They are I'd like to think I'm not an idiot. I mean, for the most part. They're coming up with something. They're cooking something. And I don't know what they're going to come up with. But I kind of feel like that, are these guys sure? Are the 6 of them up top sure they have not painted themselves into a corner, which now they can't get out of? And Gorsuch is very concerned. He's like, I don't know where this path leads, and I don't know what the ambush point is. I don't want to walk down it. And you guys just like ran down the path with your hair on fire. Like, you don't know like what's around this corner. He's like, I'm not gonna walk through the deep, dark, spooky set of woods without a flashlight. And if we don't have a flashlight, guess what? I'm not doing it. I like I said, I don't know what is planned here, but there are people far smarter than me that are probably game planning this out right now.
Yeah, and I think that there should be oral argument. There should be full briefing, and I hope we get it, because he's right. There's a lot of. I am having spent 4 hours on this with you. I am left with more questions than answers, which is exactly where he landed. Right, like there's a lot of stuff going on here. I don't feel like there's a clear line of cases that explains to me what the law should be. So, hopefully, the parties sort this out and it comes back up.
Yeah,
we'll see.
And I think there's a lot of questions though that Gorsuch has some opinions on that I think we could all agree on, and I think even Pisco is here. There's a lot we're agreeing on. There's some like, what does regular forces mean? Okay, that's an issue, but like the rest of it, I think there's a lot of agreement on what actually can happen here, what can't happen here.
Candidly, I'm happy that you got content, Sean, but I am irritated selfishly irritated that Alito's opinion was so long and said so.
Oh, I am too. This is
it's just like, fuck, man.
Alito just fucking robbed 3 hours of my life. Like, I thought we could read that girl's like nonsense like essay. Like, I read it and I was like, okay, she probably didn't deserve a 0, but she definitely failed.
Oh yeah, no.
And it's like, okay, like it sounds like 2 morons collided. The dickhead TA and her collided, and it just happened to be that that the one of them had to 2 massive forces collided, and one of them had to win. Well, the moron that was writing the paper beat the moron grading the paper this time.
I mean, I used to be a teacher, man. Like, you got to know how to, like, what I mean? Like, you never give a 0. You're like, all right, well, I'll give you like a pity 2 in this category and a pity 2 in that category. Yeah. You still fail.
Yeah.
Right? I'm just not going to give you a 0 because that's so obvious that I'm just like,
like I could have covered like two lawsuits. I could have covered a bunch of Russell Greer stuff. I need to get caught up on Destiny stuff. I could have painted some fucking model tank if I wanted to.
Look at that beautiful tank.
Well,
I'm
it's a nice
going to go to bed, man.
I could have done all kinds of stuff, but Alito just robbed us of that.
Alito robbed me of my evening.
Yeah.
But I'm going to go to bed
Oh.
quickly because I am fucking dying here, Sean. But
I am too, man.
If I'm going to give my little plug, I was hoping to preview this tonight, but I didn't get to. So because obviously Alito robbed us all. I've been reviewing, as you've seen, Amy Swearer's arguments against universal birthright citizenship on my channel recently. I've gone from 80% Trump loses that case to now I'm thinking I'm going to go on Sarah Tomato's show and just fucking throw down and tell people why Trump's going to win that case. So I've developed some birthright citizenship arguments. I'm ready to defend them. And if you're interested in the birthright citizenship case, come by my channel, watch me throw down. I think.
When are you doing this?
Probably January 8th is when their debate's going to be. Is my guess. She wanted to do it on the 1st, but I was like, I'm not doing it on January.
On New Year's Day. I mean, like, I like the law, but I'm like, I don't like it that much,
But also, like, she wants to do like a throwdown, which is like, I think the format of that is that like I basically talk to her for an hour, and then she just like opens the floodgates of like random people who want to like attack me, and I have to defend myself against all comers.
And
I can't do that hungover as shit.
Yeah, I guess that's true, but this is kind of one of those times where it's like, I get she wants to talk to you, but this is really going to be one of those times where it's like, I'm not saying you're an attorney. If you're not an attorney, you can't like make legal arguments. But I've listened to what Amy Swearer was doing. Like I listened to that thing you were watching. And I'm not like, she's not an idiot, but like, I can't talk to an electrician about electrical work. Like this is just not gonna like.
And Amy Swearer dug up some deep cuts.
Like,
these are not.
And she's arguments. A smart and I followed her for a long time. She's a smart woman. Like I said, I understand this stuff. Like okay, but like I'm not afraid to acknowledge there are people out there more intelligent than me on these topics.
I mean, she is. I was really impressed by her, and then. About like a third of the way through, maybe 2/3 of the way through, I was like, God, this woman really speaks my legal language. Like everything she says appeals very much to my sensibilities.
Yes.
And then I realized she's holding a mug with Justice Scalia's face on it. And I was like, oh, holy shit, this is the most base woman in the world.
There's much iron in her words, as the Indians would say.
For sure.
She's like, I hope she comes out to talk to you because it's like, I got nothing.
I would be really psyched about it. I appreciate you, helping me out with that on X. I haven't heard from her, but fingers crossed. So anyway, gang, if you appreciate me and Sean's frustration working through this or the analysis, please drop by the channel. Love to have you. And for the record, Sean, thank you because as you said earlier, I finally got my little baby channel monetized, and a big part of that was guest spots here and the support of your community. So I'm very thankful to you and your insane.
Don't give these people
motley crew of chatters. No, I'll be nice to them now. I'll gloss them now, and then they'll show up on my channel. I'll fucking kick them to the curb. So
so
gotta have a system.
Yeah. Well, thanks for being here, Ryan. I appreciate it. We'll have to talk again soon, man.
Yeah, man. We should do this again sometime.
Merry Christmas in the meantime.
Yeah, Merry Christmas to you. And maybe our Christmas present will be the administration winning a decision so that it's not such a doom and gloom. ED Raptor with the $5 at the 11th hour. Look at this guy.
You need a lot more than $5 to make that happen, EW.
That's not a $5 dono.
Yes.
Yeah, at this point, you'd be having to drop some Factorio money if you were trying to keep Sean on stream.
That's your money. That's in your chat. He dropped that over there for you.
Oh shit, that's for me. It's not enough for me either, buddy. But I appreciate it and you.
Yes. But anyways, Ryan, thank you for being here, man, and I'll see you around.
My pleasure, Sean. Always good to see you.
Yep. Bye. Good night. Wow, 2:00 in the morning. God. Fucking Alito, that was fucking awful. Jesus. 24-hour stream. Hey, Zero Fox, how you doing? Management say stream is not ending. Yeah, well, manage these nuts. J-Rock says all night. No, I gotta wake up and I gotta go get groceries for Christmas chat. No, but there's a programming note. Christmas Day, and I'll put the link here because apparently I fucked up the algorithm for some of you guys where you're like, YouTube is telling potentially criminals a fucking model channel for some reason. Whatever, I guess at this point. Fuck it. We're going to be over on the model bench. We have to clear up some of the models and shit we got going. So, like, my plan is, like, Christmas Day, like, 9, 10 o'clock, we're going to get started, and we are going to go for, like, I don't know, till, like, probably 5 or 6 o'clock and just knock fucking models out. So, that's the game plan, at least. Jarek says, you don't have Instacart? Instacart fucking charges a lot, dude. Instacart's getting in trouble for fucking ripping people off. Also, you get fuel points if you use Giant Eagle, and also it gives me a chance to go out of the house. So, but no, we're going to do that Christmas Day. Seller says, going on the 24th? Well, I pull up in the parking lot and say, hey, I'm here, and they come out with the food. So, yeah, that's the plan. We're not knocking models up. We have to knock them out. We have a bunch of models we got to take care of. We got to get the train sorted out. We got to get the Dauntless done. We have to get the Sturmovik done. We got the F-35 done. We're gonna get it all done, chat. We're getting it all done. So, yeah, Instacart got busted fucking around, people. So, disconnect Ryan's stream or moon the camera, your choice. Oh, end Ryan's stream. Okay. I think I have to remove there. Ryan's done. There you go, Ryan. Bye. And I think I have to remove his Twitter too. Remove there. There we go. All done, chat. Now it's just us. Zero fucks if you're gone. Come back over here. So, well, thank you. Thank you for being here now. Let's see. Jamal will get the right potato. We actually don't need potatoes. We actually have patatas that we're going to mash. That's right, chat. On Christmas Day, I'm going to mash my own potatoes. Potatoes. So. Do the Black Lady Justice opinion now. Well, there's nothing there. Yes, future Mrs. Mark 2.0. Thanks. All right, guys. Well, hey, I got to end this. I got to go take a massive leak, and then I have to go to sleep. And I don't want to go to sleep before I take a leak because I don't want to pee in the bed. So, good night, chat. And, no, I'm not using, I'm not doing the Robichon mesh fizz. I have my own way of doing it. That works really well. Chat, I will see you tomorrow. Remember, till next time, just because you did it does not mean you're guilty. Except you're Sammy Alito, you're guilty of cringe. Good night, chat, and I will see you guys tomorrow.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy?